is cannabis. For some reason, they filed it as possession of controlled substance. I will ROR him. Mr. Hudson, you're going to be released today so that you can go to your program in Judge Port's division that you were released to. Do you have a phone number for him? Ms. Carr, do you want to get it now?
Judge, I was able to get 2 phone numbers from him, so I'm okay.
All right, thank you. All right, Mr.
Thank
Hudson, you, sir, you're going to be released today so you can go to your program. Take care.
Have a nice day.
All right, and I just was advised by my JA that Mr. Reynoso's brother advised you will log on and cover for him on Mr. Carvajal. So once that gentleman logs in, we'll take that case. Let me take the one Spanish interpreter case, since I do have our Spanish interpreter here in the courtroom, and then we'll take the private attorney cases. All right, so this is on page 5. Mr. Sapan Alvarez.
President.
All right, just give me 1 minute. Can you unmute the podium, please? He needs to, you guys, I don't know how to unmute the podium.
Anxiety.
You did.
We're coming to get you. I came out. Got it.
Nope, that didn't work.
Yeah, you should, like I said, you got the order signed, so hopefully they're gonna go ahead and evaluate you to see what medication.
You know how to unmute the podium?
Oh, no, they're talking about the podium.
Oh. We're talking about my.
Oh, no.
There it is. All right, please raise your right hand for me.
Yes, ma'am.
Do you swear or affirm to translate from Spanish to English and English to Spanish to the best of your ability?
I do agree with Sinisi certified Spanish court interpreter.
Okay, thank you so much. This is Mr. Sapan Alvarez on page 5.
Thank you. You're
Good morning. The court does find probable cause for touch or strike battery domestic violence.
El tribunal sí dictamina que existe un motivo fundado para el cargo de contacto o expresiones.
Mr. Linder, first to you.
Señor Linder, primero a usted.
Judge, I see no history.
Señor, no veo antecedentes.
I'm recommending a $1,500 bond and no victim contact
Estoy recomendando una fianza de $1,500 y no tener contacto con la víctima,
based on the level of violence,
basado en el nivel de
the
violencia
allegation that the battery was witnessed by law enforcement.
y la alegación que el acto de lesiones fue observado por las fuerzas del orden
Nothing
público.
further.
Nada más.
Thank you, Mr. Romero.
Gracias, señor Romero.
Mr. Sapan has been living in our community for the past 18 years.
Your Honor, I can barely hear Mr. Romero.
Mr. Sapan has been residing in South Florida for the past 18 years.
El señor Sapón ha estado residiendo en el sur de la Florida los últimos 18 años.
He works in construction, and my understanding, Judge, he does live with the alleged victim, but he has a place to live separate and apart from the victim.
Él trabaja en construcción. Entiendo que él vive con la víctima, pero tiene un lugar donde residir ahora separado de la víctima.
Judge, more importantly, this is his first contact with the criminal justice system.
Más importante, su señoría, este es el primer contacto que él tiene con el sistema penal.
Considering this is a misdemeanor offense, he did advise me he will be coming to court to address these allegations. I'm going to be asking for a $500 bond to be provisionally appointed on his case.
Considerando que él quiere pelear el caso, estoy pidiendo una fianza de $500 y que se nos nombre la representación de nuestra oficina para este caso.
All right, bond is set in the amount of $1,500.
La fianza es fijada en un monto de $1,500.
You cannot return to the soccer stadium referenced in the police reports.
No puede regresar al estadio de fútbol que está referenciado en los informes policiales.
You also, as a result of the domestic violence nature, cannot possess any firearms, weapons, or ammunition while your case is pending. Do you understand?
también porque es un caso de naturaleza de violencia doméstica, no puede estar en posesión de armas de fuego, armas o municiones, ¿entiende?
He's muted, guys.
¿Entiendes? Sí. He answered in the affirmative.
Okay, you also cannot have any contact, direct or indirect, with the listed victim. Do you understand?
Entiende que no puede tener contacto directo o indirecto con la víctima del caso.
Más fuerte.
Sí.
Yes.
That means not only can you not live with her, you cannot call her, text her, email.
Eso significa que no solamente no puede vivir con ella, no puede llamarla, no puede mandarle mensajes de texto, no puede mandarle correos electrónicos.
Social media, letters, or having a family member or friend send a message to her.
Eso también significa que no puede tener contacto a través de medios sociales, cartas escritas, ni que parientes o amigos la contacten a través de o de parte suya.
Or any other means of communication that I have not said. Do you understand?
O cualquier otro medio de comunicación que no he anunciado. ¿Entiende eso? Yes.
I will provisionally appoint the Office of the Public Defender to represent you during the pandemic.
Sí voy a nombrar provisionalmente al abogado público, de la oficina del abogado público para que lo represente durante la pandemia.
Once COVID is over, you will need to reapply to make sure they keep representing you.
Una vez que concluya COVID, tiene que reaplicar para que lo continúen representándolo.
Anything else on his case we need to address?
¿Algo más que tengamos que abordar en este caso?
No, Judge.
No, señora jueza.
Good luck to you, sir.
Suerte, señor.
Do you need the case number?
I have it in the docket. Thank you so much.
Thank you so much. All right, have a good day.
Likewise, John. Thank you.
All right, Mr. Reynoso, thank you for joining us. This is on Mr. Carvajal on page 11. Do I have that paperwork, Madam Clerk? All right, so do you guys have Mr. Carvajal de Avila there? We have his attorney here. This is one of the cases we needed out of turn.
He's approaching, Judge Germain.
Okay, thank you. All right, sir, good morning. Make a finding of probable cause for sexual battery by a defendant over 18 on a victim under 12 years old. I also make a finding of proof evident presumption great, and I do so without prejudice. At this time, based on the allegations, he's going to be held no bond. Mr. Reynoso, your office is representing him, or your brother's office, is that correct?
My office that's representing him at this point, Luis Reynoso, on behalf of Mr. De Avila.
Okay, thank you. So, sir, you cannot have any contact, direct or indirect, with the listed victim, KR. Do you understand?
I think he's an interpreter, Your Honor.
I can't hear him.
Your Honor, he's saying he needs a Spanish interpreter.
Is anyone able to run out and grab the Spanish interpreter that just left by any chance?
And Your Honor, just to be clear, Your Honor had indicated that you found proof evident presumption great. I mean, are we doing an Arthur hearing at this time?
No, sir, you still have the ability to do an Arthur hearing, but for now we have to wait because he needs a Spanish interpreter, so he needs to be on recall.
Okay, I'll hold then, Your Honor. Thank you.
All right, thank you so much. So, okay, so let me do Mr. Marquetta's case, and then I'll do the other two individual defendant attorneys in the room and their defendants. So Mr. Marquetta's client is Mr. Johnson on page 13. Are you waving his, okay, looks like he's approaching. All right.
Judge, again, Arthur Marquette on behalf of Mr. Johnson.
All right, Mr. Johnson, good morning, sir. Your attorney, Mr. Marquetta, is here on your behalf. At this time, I do find probable cause. It's a signed warrant on a robbery with a gun or deadly weapon that you're being held no bond on. You have a first VOP tomorrow with your division judge. Who took over FX? Is that Judge Fine? I believe that's Judge Fine. Yeah,
Judge, that's correct.
Correct. Sorry, my apologies. Tomorrow at 8:30 a.m. So he'll have to go before Judge Fine with regards to the no bond hold, Mr. Marquetta. I cannot change that no bond hold because it is a signed warrant. So is there anything else that we can do? Because I gave you a date for tomorrow. That's good.
Judge, the only thing I wanted to point out is this man is coming back to Broward County with substantial amount of credit for time served, some 12 or 13 years. The charge was solicitation to commit armed robbery. So in essence, he's pretty close to being almost a time served situation. Close, not exactly there. So at this stage, I'm simply asking the court to consider setting a bond, and this way he can make his decision as to whether or not he wants to bond and show up tomorrow or show up through the back door.
All right, thank you, Mr. I cannot change another division judge's signed warrant, so unfortunately, he's going to have to see Judge Fine tomorrow, okay?
All right, Judge, thank you.
All right, thank you. Take care. Good luck to you, Mr. Johnson. You'll see your division judge tomorrow. All right, and let's call Rock. That's the next person I had checked in. His attorney, Mr. Allman, is present on page 4.
He's coming up. Mr. Geyer, that's your turn.
Is it the victim? You can come and sit in, but unless, okay. Thank you. He has a family member here, but she's not the listed victim, so unless she's called by one of the attorneys, she just has to take a seat. All right, so Mr. Gyra, good morning, sir. The court does find probable cause for touch or strike battery, domestic violence. Let me put this on mute. Mr. Linder, first to you.
Your Honor, I'm recommending $1,000 bond, no victim contact based on the allegations. The only prior I saw was a dated battery and resisting without violence from the mid-90s. Nothing further, Judge.
Okay, thank you. So Mr. Allman, next to you, sir.
Good morning, Your Honor. Jason Allman from Green Spoon Martyr on behalf of the defendant. The defendant does have a sister here. If Your Honor would let her say a few words on behalf of the defendant.
All right, sure. If you want to call her up, I'd have to swear her in.
Paula Gyrock.
All right, ma'am, good morning. It's my understanding that you wish to say something to me, correct?
Yeah, I just wanted to.
Okay, so hold on. So listen to the question. Please raise your right hand for me. Based on that, do you swear or affirm to testify to the truth, the whole truth, and nothing but the truth, ma'am?
Yes.
All right, thank you. You can put your hand down and state your name for the record now that you're sworn.
Paula Gyrock Love.
All right, ma'am, you are here, okay, so to tell me something, and what is your relationship to Mr. Gyrock, the defendant?
His sister.
All right, what is it that you wanted to tell me?
Just that, he's a very upstanding person. He has, had his own business and been very involved in that. And I just want to speak to his character.
All right, thank you for being here. Mr. Linder or Mr. Allman, do either of you have any questions for him? Her, my apologies, ma'am.
No, Judge.
No questions, Your Honor.
All right, thank you.
Thank you.
All right, thank you for being here. All right, so Mr. Allman, what is the defense's recommendation?
So, Your Honor, the defendant runs a successful business out of the back of their property. They currently have a few acres of land where the residence is located. And in the back of the residence, they have about a 5,000 square foot warehouse. And upon information and belief, the husband is the sole income for the family, and they live in the same residence of the child who is the victim here, who is of majority age. So I'm seeking, Your Honor, to maybe see if the adult son could reside in a separate residence with that of his grandmother, who lives only 2 miles away, so that the defendant can continue to operate the business that runs the family, that is, again, in the back of the property where the residence is located. Your Honor, the defendant is not a flight risk, nor is he a danger to himself or the community.
All right, thank you so much. So based on the allegations, the prior battery, just note, Mr. Gyrock, you could be charged with a felony battery due to priors, which is a third-degree felony based on that prior conviction from the 90s, although it is dated. Please also note, so I will set your bond in the amount of $1,000. The conditions of your bond, even while you're in custody, I am ordering that you not have any contact with the alleged victim until further order of the court. Your son, I'm advised he's an adult. I'm not saying you can't go back to the home. What I'm saying is that if he moves out, you can live there, but you cannot have any contact with him, direct or indirect. Do you understand?
Yes.
All right, means no phone calls, text messages, emails, social media, letters, or having a family member or friend send a message to him for you. Understood?
Yes.
Also, based on domestic violence nature, you cannot possess any firearms, weapons, or ammunition while your case is pending. Do you understand?
Yes.
All right, thank you. Anything else from either party on Mr. Gyrock's case?
No, Your Honor.
No,
Thank
Judge.
you.
All right, thank you. Good luck to you, sir. All right, next is Mr. Matalon on page 6. Mr. Rabin is here on his behalf.
Good morning, Your Honor. Dave Rabin on behalf of Scott Matalon.
Good morning again, sir, and good morning, Mr. Matalon. The court does make a finding of probable cause for kidnapping, count 1. I also make a finding of proof evident presumption grave, but I do so without prejudice. Count 2, I do make a finding of false imprisonment of an adult. Count 3, domestic battery by strangulation, dating relationship. Count 4, touch or strike battery, dating violence. Hold on, let me mute this. Mr. Linder, first to you.
Your Honor, on count 1, the state would be seeking a no bond hold. On count 2, I'd be recommending a $7,500 bond, a $7,500 bond on count 3 as well, $2,500 bond on count 4, no victim contact. Just for the record, I believe Mr. Rabin has prepared a proposed order for the court allowing photos to be taken of his client. I just want to put on the record, I have no objection to that, Your Honor. I can also advise the court, my office has attempted to contact the alleged victim. I've been advised there's been no contact at this point. Your Honor, additionally, making these recommendations based on the allegations in the case, that the alleged victim first retreated to a neighbor's home, was forcefully brought against her will back into the defendant's home, that she was then falsely imprisoned inside the defendant's closet, even when law enforcement arrived, Your Honor. And law enforcement observed her running out of fear out of the residence, Your Honor, upon her, once they made entry into the home. I can advise the court, and Mr. Madeline does have a pending battery out of Palm Beach County. I just want to advise the court. Mr. Rabin was forthcoming about that. He advised me that this morning, so I do appreciate that. I do see, Your Honor, that checking, there have been, I believe that was domestic violence. I don't believe it involves the same alleged victim, Your Honor, from what I can tell. That was last month in Palm Beach County. Just checking, I see that there are, and I don't know if pretrial has any notes. I'm getting hits on other protection orders out of New York that were previously issued involving Mr. Matalon. I cannot be completely certain if they involved him or not. I can tell you that, Your Honor, an order of protection was issued on June 17th of this year in Palm Beach County, protecting one individual, and another was issued on June 25th. That is set to expire in 2 days at this point in time. Yeah. Yes.
Okay, thank you, Mr. Linder. Rabin?
Morning, Your Honor. Dave Rabin on behalf of. But just a little bit of background. Mr. Matalon is 40 years old. He's married with 2 children. He's a homeowner. He is a college graduate with a BS in business. He is a certified financial planner in both retirement and mutual funds. He has Series 7, 66, and 63 licenses. He's employed by the Royal Bank of Canada for the last 2 years and Ameriprise for 6 years prior to that. He has no felony priors. I did advise the state regarding the misdemeanor battery, and those protection orders arose out of that. That's a Palm Beach County case. It has not yet been arraigned. What I'm asking the court to do is consider setting a bond in light of the defendant's background and history in the community. I'd ask the court, I know the court has announced it's made a finding of probable cause as to kidnapping, and that proof is evident and the presumption is great without prejudice. I'd ask the court to consider setting a reasonable bond that would include a no contact order, GPS, and a bond in the amount of $100,000. I think that would assure Mr. Matalon's appearance and would be a reasonable bond under the circumstances.
All right, thank you. I will exercise my discretion, although I am finding proof evident presumption great on count 1. I will set bond in the amount of $100,000. Count 2, I will set bond in the amount of $7,500. Count 3, $7,500. count for $2,500. Once you post bond, sir, you're going to be supervised by pretrial release level 2 with a GPS, meaning you can go to work with a pre-approved schedule and you can be at home. Do you understand? All right, you cannot have any contact, direct or indirect, with a listed victim. Do you understand?
Yes, ma'am.
That means you cannot be where she lives, works, call her, text her, email, social media, letters, or any other means of communication that I have not said, including having a family member or friend send a message to her. Do you understand?
Yes, what about my stuff that may be there? Can somebody pick that up? Yes, some of my.
Was she living with him, Mr. Linder? It indicated they were together for approximately 2 months.
No.
She has boots in the back of her.
Frankly, because you're with GPS, you're gonna have residents reach out to the contact the alleged victim and ensure, to verify what she is, so we'll be able to determine that they're not in the same location.
Okay.
It's separate residences.
Okay, thank you, Mr. Raven. So I've been advised that it's a separate residence, so you can't go to her home. I'm not allowing you to go to her home. Do you understand?
Worse.
All right, you also cannot possess any firearms, weapons, or ammunition while your case is pending based on the domestic violence nature. Do you understand?
Yes, ma'am.
All right, and I am going to sign this order as well, prepared by your attorney with no objection from the state, allowing your attorney to take pictures of you while you're in custody. Anything else in Mr. Matalon's case that we need to address from either party?
No, Your Honor.
All right.
You say he's not allowed to go to the victim's residence. Are you also going to include her place of employment?
I said work too.
Okay.
I already said work. All right, thank you. All right, take care, sir.
Thank you.
All right, I have our Spanish interpreter back. So let's recall Mr. Carvajal de Avila. Where did I put his paperwork? All right, so welcome back. You are still under oath. Thank you for coming back.
Yes, Your Honor. Okay.
He's on page 11. So let's do this again. Mr. Reynoso is here on his behalf.
Yes, Your Honor. Good morning, Luis Reynoso on behalf of Mr. Carvajal de Avila.
All right, so good morning, sir. The court does find probable cause for sexual battery by a defendant 18 years or older on a victim under 12 years old.
Bienvenido nuevamente, señor Sidi. También que existe un motivo fundado del tribunal para el cargo de acceso a arma violento de la víctima menor de 12 años y el agresor mayor de 18.
I also make a finding of proof, evident, presumption, great, but I do so without prejudice.
También determino que decreto que existe prueba convincente y evidente, pero sin cosa juzgada.
And Mr. Reynoso, it sounded like you wanted to make some argument before I made my rulings as to bond, sir.
Y señor Reynoso, parece que usted quería presentar unos alegatos antes de que yo haga mi decreto con respecto a la fianza.
Your Honor, I don't have the benefit of the arrest affidavit or the arrest warrant. So I'll let the state make their argument and then I'll rebut if I may, Your Honor.
So let's put it on another brief recall, Mr. Linder. Mr. Reynoso, can you please provide Mr. Linder with your email address and he'll email it to you? It's they're pretty serious allegations, so I want you to be sure what you're arguing before we go forward.
Sure, Your Honor. And my email address is LUIS.
Your Honor, I can't hear what he's saying.
Yeah.
Hold on.
With the echo to interpret, it's impossible.
No, I turned mine off here. He said he needed his email address so he can review the probable cause affidavits.
Can they hear me any better now?
Okay, so Mr. Reynoso,
Hello?
whenever you get a chance, please provide your email.
Yes, it's LUIS at REY.
Speaking, I can't hear it. Literally, I had
We
nothing.
can't hear you, Mr. Reynoso. The headphones aren't working.
Your Honor, I'm trying to. Can you hear?
I can't hear because I had to take my speakers off, so there's no echo.
Can they hear me now?
Yes.
Yes.
Okay, it's LUIS at Reynoso, REYNOSO, LAW, P as in Peter, A as in Apple.com.
And Your Honor, just something I just realized.
Our full name's in there. It needs to-
Well, one, I'm not able to redact from here before I send.
Una cosa, no puedo redactar eso o cambiarlo hasta que yo antes de mandarlo.
And two, when I was appearing from home, I had the ability to pull the PCs from the entire packet and send them.
Y lo segundo era que cuando yo estaba trabajando desde casa y comparecía de ese lugar, yo podía sacar el actividad policial y separarlos del paquete completo.
I tried this morning from this computer and am unable to.
Are you able to scan the police reports to Mr. Linder for Mr. Carvajal and redact the victim's name before you do so?
Puede mandar, por favor,
Official court file.
el nombre de la víctima para el señor Reynoso.
I need a black Sharpie, please. Her name cannot be in here.
Eso no puede aparecer así.
Thank you. All right, so do you want to redact it as well, Ms. Cooper? Do you need a Sharpie? All right, so we're gonna have to put him on recall so that can be sent to him once we do the redactions here in court. Her name cannot, based on these sexual abuse allegations, it should not have been in here. Mr. Linder, please let the detective know this very grievous mistake.
I'm sorry, Your Honor?
Please let the detective know the big mistake that they made by putting the victim's name in here.
Por favor, informe al detective el error que cometieron al poner el nombre de la víctima. Entendido.
I'll make a copy first.
Oh. I was asking him to let the detective know the mistake.
I heard you.
Oh.
They speak, because I had trouble reading.
Oh, okay, I'm sorry.
Is it possible for us to do this via Zoom?
You can log in by Zoom. Yeah, yeah. That might be easier next time.
So I head to my office and,
Yes, since we have to do this, if you want to log in to your office, yeah, that'll be great, because they still have to read. So. Okay, thank you so much.
Okay.
Okay, so there were 5 spaces that I saw the victim's name. Do you see any more, Mr. Linder or Miss Cooper?
Do I have any?
I redacted five full names of her name. I redacted on page 2.
Marker, pen. But I'm reading copy so then you can take it out and I'll,
Okay, thank you.
No,
Actually, I
it doesn't
have
work.
6 redactions. I have 2 on page 2.
Your Honor, did you provide a pen to use or a marker to use? No, you don't, but
Here's the
also
last
certain,
one.
what I've learned from other cases that certain things don't work necessarily.
You need to use a black Sharpie or else it's not going to redact. All right, so I had 6. Let me know if there's more than that. This case is on recall. Okay, so we can start just page 1 then. If you want to hand me the stack, I think we can just start with, actually, we have to do Paul, Ryan, and Conti. And then I'll do the stack. Thank you. All right, so let's go over to Paul Ryan. They only had 2 individuals that they needed us to take out of turn.
Yes, Your Honor.
All right, so the first person you guys have there is Miss Hollander. All right, so Mr. Linder, to you, sir, this is on Miss Hollander. Good morning, ma'am. It's a motion for 3040 release.
One moment, Your Honor.
Haven't signed it yet.
State has not yet filed an information, Your Honor, asking that the no contact order be kept in place.
All right. All right, Ms. Hollander, the state has not yet filed an information, so you are entitled to a release on your own recognizance. A condition of your release, ma'am, is that you cannot have any contact, direct or indirect, with the listed victim. Do you understand?
Yes.
I can't hear you.
Yes.
All right, was there a monitor or anything that we needed to delete? All right, is there, Ms. Chase, do you need a phone number for her so that you can have it in your file?
Yes.
Okay, Ms. Hollander, please provide Ms. Chase, your attorney, with your phone number so she has it on file.
Yes, ma'am.
What's your phone number?
I have to get out of here before I can get a phone. My phone shut off.
Okay, she said it shut off. She doesn't have a phone. All right, so Ms. Hollander, again, you're going to be released today, but you, yeah, please. But you cannot have any contact. No, you do it.
Oh,
Thank you. Sorry. My handwriting's not as good. All right, director and direct. Good luck to you, Ms. Hollander. All right, so the next case, Mr. Linder, are you ready on Mr. Mercado or no? All right, so he'll be on a recall. We'll come back to Paul Ryan. So next at Conti facility, a second look docket is Anders Lilly. Here is.
Good morning, Judge.
All right, good morning. Thank you guys for your patience. All right, this is a second look. Mr. Lilly, good morning. Mr. Linder or Ms. Chase, can you tell me what happened with this second look case? Ms. Chase or Mr. Linder? Thank you.
This came through, I believe, on Monday, for Judge Solomon, for the conveyance, $7,000 bond. There was law enforcement in Victoria. Law enforcement in Victoria Park responded to a burglary of a conveyance. Victim observed several individuals inside of his vehicle. One of the subjects was taken into custody. A perimeter was established to locate the two other suspects. Canine officers located Mr. Lilly laying on the rooftop of a residence within the perimeter. Eventually, law enforcement was able to detain Mr. Lilly. A show was conducted with the victim, and the victim identified Mr. Lilly as being part of the group of three subjects that entered his vehicle unlawfully and then took flight. That's the allegation, John.
Okay, thank you. I'm looking at the booking report. It says 0 months of residence. Ms. Chase, do you have any information for me with regards to his ties to the community?
Yes, Judge. He advised me he's been residing in Broward County for 3 years. That he currently is homeless, but he plans to live at Covenant House. He does have a phone, and I don't believe he has much of a record, Judge. And he did advise me he works at a restaurant, Outback Steakhouse. So he does have a job. The plan is Covenant House and a phone with which he could call pretrial. So Judge, I was going to ask for pretrial. I know that the $1,000 bond is impossible for him to post. Even with a bondsman, you'd need collateral. So at this point, he's not able to do that.
All right, thank you. Mr. Linder, can you tell me whether he has any priors?
I'd have to check, Ms. Worley. Thank you so much. I really appreciate it.
After this case, Deputy Davis, I'm going to call page 1, and the victim is outside. I think you told me. So if you can come in and wait, because I'm going to call that case next. Thank you.
Your Honor, he has a 2018 withhold of certification of the occupier of a dwelling. We have another 2018 case burglary of a structure, dwelling causing damage over $1,000 in whole and communication. Have a withhold of adjudication on arson. Second degree.
What year?
2000, and that was 2017 case.
Okay, thank you.
Okay, 2000, was just arrested this year for violation of probation felony. He has a 2019 grand theft.
That's a BOP.
And receiving stolen credit card. That, he had a withhold of adjudication. Let me see what case the violation of probation was on.
And these are adult cases? I was just,
Are these adult cases? They sound like.
yeah. I was under the impression it was, okay. There were some juvenile, but nothing else.
Excuse me, those were juvenile cases.
Must have been direct file because you received withholds.
Okay.
No,
Didn't say
I
that
was not
they were
direct filed.
delinquency.
Right, yeah, because that's what my understanding was. There was mostly juvenile issues, so I
And
didn't.
they're still within the 5-year period.
Understood, yeah.
2019, November 2019, he has another burglary on a private dwelling unarmed withhold of adjudication. Grand theft from a dwelling withhold. Criminal mischief withhold.
All right, thank you, Ms. Morel. So I'm going to take no action. Based on those very serious priors, I am going to take no action. Good luck to you, sir. You cannot have any contact, direct or indirect, with the listed victim. You'll have to file a motion with your division judge.
Okay.
All right, so just Mr. Reynoso, let me know when you're ready. Otherwise, we'll start on page 1 and you just let us know and we'll take your case out of turn, okay? Yes.
Just to confirm, anywhere where someone's pulled in, because of the situation, it's really easily misidentified.
So you want me to redact the mothers and the siblings' names?
I think so, just because it would kind of make it clear. I'm not, obviously not a
Correct.
mother, father.
Okay, that's fine. All right, so let's start on page 1 with Miss Williams. The listed victim is present in the courtroom. All right, Miss Williams, good morning, ma'am.
Morning.
The court does find probable cause for touch or strike battery, domestic violence, criminal mischief, $200 or less, first offense, and a capias for another battery with the same listed victim, Mr. Henry, who's here today in court. Mr. Henry, good morning, sir.
Good morning.
You are the listed victim. Are you here to tell me something, or did you want to just see what happened?
Just to see basically what happens.
Okay, so please raise your right hand for me, sir. Do you swear or affirm to testify to the truth, the whole truth, and nothing but the truth?
Yes.
All right, thank you. You can put your hand down and state your name for the record now that you're sworn in. All right, Mr. Henry, you are the listed victim and you're here without an attorney. So I need to advise you that you previously spoke with law enforcement. So anything you say today can be used against you. Do you understand?
Yes.
All right, sir, what is it that you wanted to tell me?
I basically want to say that I don't even want to file any charges. That's basically it.
Okay, thank you. Does any party have any questions for Mr. Henry based on his testimony today?
No, Judge.
Okay, thank you. All right, thank you for being here, Mr. Henry. All right, so Mr. Linder, let me take my mute this. It's first to you, sir.
Judge, based on the totality of the circumstances, I'm asking that the court set a $500 bond on count 1, $500 bond on count 3. No victim contact on the new case. The reason I'm not asking for anything higher, Your Honor, is it would appear, I have nothing to provide the court to indicate that a no contact order was ever issued on the Capias case. It looks like it was a technical matter since it was an issue summons, and I believe bond was posted prior to the first appearance, Your Honor. And I don't know that it was ever, an order was ever issued when she appeared before Judge McHugh, or didn't appear before Judge McHugh.
Okay, thank you. Ms. Chase?
All right. I do know that she's a lifelong resident of Broward County. She recently started a new job at the Hard Rock in the cleaning department. She does have 4 children, one of which is a newborn. She pays rent at her home that she rents and resides. I think she may have some money. If I could just ask Ms. Williams, you mentioned you could bond out. Did you still want to ask for pretrial, or could you do the bond on what was just announced by the state? I can't hear her.
Are they able to do the pretrial?
I'm sorry?
Are they able to do the pretrial?
I was going to make a request for pretrial, Judge. I don't know if the court would consider it.
No, ma'am. Based on these allegations, there are 2 separate incident dates with the same listed victim.
So it would be $1,000 if you're able to get collateral, it would be a bondsman. I think we discussed that. Is that something you can do?
Okay, you said 1,000?
It's 500 for that KPS and 500 for the battery charge.
Okay.
Judge, we're fine with that. I think in speaking to her, that's something that she can afford, and this, if the court's not going to consider pretrial.
All right, thank you, Ms. Chase. Ms. Williams, I am going to set bond on count 1 at $500. I'm leaving the KPS amount set by your division judge at $500 on count 3 for the other battery. Cannot have any contact with the listed victim, Mr. Henry, direct or indirect. He's here in the court. I do know there's a history of domestic violence where he's the listed victim based on the 2020 as well as his 2021 case. Do you understand you cannot have direct or indirect contact with him?
Yes.
That means you cannot live with him, call him, text him, email, social media, have a family member or friend send a message to him, or any other means of communication that I have not said. Do you understand?
Yes.
You all do not possess any firearms, weapons, or ammunition while your case is pending based on the domestic violence nature. Do you understand?
Yes.
And I will provisionally appoint the Office of the Public Defender to represent you during the pandemic, ma'am. Once COVID is over, you will need to reapply to make sure that they keep representing you. Is there anything else in Ms. Williams' case that we need to address?
Judge, if I could ask her for her phone number.
Go ahead. Ms. Williams, can you please provide your attorney with your phone number so she has it in your file, ma'am?
561-291-4789.
Thank you.
All right, good luck to you, ma'am. Good luck to you, Mr. Henry. Thank you for being here. All right, next is Ms. Thomas on page 2. Ms. Thomas, good morning, ma'am.
Good morning.
Does find probable cause for trespass. Mr. Linder, I couldn't tell where the what the area was. It gave an address.
One moment, it's, one moment, Your Honor. Yeah, I don't have the name of it, but apparently it's a park.
Okay, so does the state have an offer if she has any priors and wishes to resolve? Has her hand raised, sorry. Yes.
Ms. Thomas was released a pretrial sentence on division on the 15th of May 2021, case number 214604 CFNA, possession of MDNA, MDNA. As of the date of her arrest, she has not showed or called pretrial for her intake. The telephone number that was provided to pretrial services in court was the wrong number. On June 9th, pretrial mailed out a letter to the defendant to contact us for her intake. So no one will at this time, they're going to request the revocation of her certificate of education.
All right, thank you, Ms. Worrell. Mr. Linder, the state's position on pretrial's request and an offer if she wishes to resolve.
Your Honor, if she wishes, this also as a 2018 disorderly conduct, if she wishes to resolve this case, the offer would be to withhold court costs, no return. Your Honor, I would recommend that the court grant the pretrial request not necessarily based on the new law offense, but based on the information provided that she has been non-compliant with keeping in touch with pretrial. So I don't believe she's a good candidate for pretrial. But I would recommend that the court set the standard bond back on the drug possession charge of $1,000.
Okay, thank you, Ms. Chase.
Judge, I can advise that she's been a lifelong resident of Broward County. She is currently unemployed. She was working in a hotel. Unfortunately, this arrest is going to cause her to lose that job because if you don't show up, you lose your job. She was residing in a shelter. I believe she was evicted from that shelter, which might be part of the address issue. And so, you know, she does have a 9-year-old son that she pays money to support, although he's not residing with her. Judge, as to the pretrial case that she's currently out on, I'd ask Your Honor to take no action. The pretrial could submit a warrant if they chose, I understand, but at this point I'd ask Your Honor to take no action and allow us to try to link her with pretrial. I think that likely it was the eviction issue that she suffered that caused this problem with pretrial. And I'd ask the court to release her on pretrial in this case as well. If, you know, I can contact her. I didn't mention resolving the case to her because I was aware of the issue going on with pretrial. I can contact her and we can see about resolving this trespass. But again, I'd ask Your Honor to leave her on pretrial on that other case.
All right. So I do know it is the Northwest Branch Library. I had to look it up while we were talking. It's a library in Pompano Beach. Ms. Thomas, I understand pretrial's request. I'm going to take no action and I will put you back on pretrial release on this new law offense with an order of no return to the Northwest Branch Library in Pompano Beach. Do you understand?
Yes.
That means that you're going to get out today, but you have to call into pretrial release tomorrow before 11 a.m. A good phone number where they can reach you.
Yeah. My phone number?
Yes.
772-277-3748. No, 84. My apologies.
You get that, Ms. Worrell? 3784?
Yes.
Okay, that's what she says. Is that different than what you have on file? And I will provisionally appoint the Office of the Public Defender to represent you during the pandemic. Ms. Thomas, once COVID is over, you'll need to reapply to make sure that they keep representing you, okay?
Yes.
And Ms. Thomas, you are going to get a piece of paper given to you with a number for pretrial, so make sure you call.
Yeah.
Okay. You need to call that.
Yeah.
Okay, so it's a different phone number. All right, Ms. Thomas, good luck to you, ma'am. Call in tomorrow, okay?
Yes, thank you.
You have an address also, just in case the address.
I really want to put it on the record because we're live streaming. Did you get an address by any chance you can provide to Ms. Worrell? Okay. She's homeless, Ms. Worrell. All right, next is Ms. Ray on page 2.
She's here present, Judge, on Maine.
Okay, thank you, Ms. Ray. Good morning, ma'am. The court does find probable cause for trespassing. Mr. Romero, is she interested in an offer from the state?
Judge, I spoke with Miss Ray. She's homeless. No one can afford to post her bond. I'm asking for an ROR. However, if the court's not inclined, I'm going to be asking for a mental health screening. I do have concerns. I'm going to also be asking that this case be transferred to Judge Lerner Wren.
All right, Mr. Lender, does the state wish to be heard? Okay, so I'll leave the bond in place per Judge Lerner Wren's request because she asked that all of the mental health cases leave the bonds in place. So she'll be transferred to mental health court. I'll sign a mental health screen. And I will also order no return to the Beachway Shopping Plaza, okay? And I'll provisionally appoint the Office of the Public Defender to represent you during the pandemic, okay? Once it's over, you'll need to reapply if this case is still pending. Good luck to you, Ms. Ray. All right, next is Ms. Dunbar on page 2.
She's approaching at Main, Judge.
What about Ms. Ray?
Oh, am I? Okay.
Yeah, mental health screen and transfer to mental health court. Ms. Dunbar, good morning. The court does find probable cause for operating without a valid license. Are you aware of whether she wishes to resolve this case or not, Mr. Romero?
She does wish to resolve this case today, Judge.
All right, thank you, Mr. Linder. Does the state have an offer for her?
Adjudication time served.
Time served. Like, something you
Thank you,
want?
ma'am. Please raise your right hand for me to the best of your ability. Do you swear or affirm to testify to the truth, the whole truth, and nothing but the truth?
Yes, Your Honor.
All right, thank you. You can put your hand down and please state your name for the record.
Tiffany Dunbar.
All right, ma'am, it's my understanding that you wish to resolve your operating without a valid driver's license case, correct?
Yes, I am.
And do you understand the charge against you?
Yes, Your Honor.
And do you understand everything that's happened here today?
Yes, Your Honor.
Is anyone forcing you to resolve this case?
No, Your Honor.
Are you under the influence of alcohol or drugs?
Not at all.
And do you need more time to speak to your attorney?
Yes.
Yes?
Oh, no, I thought you said, did I have more?
Oh, no, not a problem. Are you, okay, so are you satisfied with your attorney then, since you said you had enough time to speak with him?
Yes, yes, yes. I'm more than satisfied now. I misunderstood.
No problem. Not a problem. And do you understand you have a right to go to trial, but you're giving up that right forever by accepting this plea?
Yes.
And have you ever been treated for a mental or emotional illness, ma'am?
No.
I'm not asking if you're a citizen. I just have to advise everybody that takes a plea before me. Do you understand if you're not a United States citizen, that taking a plea today shall subject you to deportation proceedings?
Yes, I've been here all my life, 41 years.
All right, and how do you wish to plea, ma'am? Guilty or no contest?
No contest.
All right, ma'am, I accept your no contest plea is freely, voluntarily, knowingly given. I do find there is a factual basis based on the police reports. I am going to adjudicate you, sentence you to time served. And how much time does she need to pay, Mr. Romero?
I'm going to be asking for a civil lien, Judge.
All right, and I'll convert your court costs, cost of prosecution, and PD application fee to a civil lien. What that means, Ms. Dunbar, is that it's a civil judgment that's good against you for 20 years. If you ever do come into the money, you'd have to pay that off, okay? Good luck to you, ma'am. You should be released today if nothing else is holding you. Next on page 3 is Ms. K, who has bonded. Before the record, I do find probable cause for offering or securing lewd act or prostitution, third or subsequent offense, and maintaining a place for prostitution, third or subsequent offense. Next is Ms. Jumper on page 3.
Record, Donor.
All right, Ms. Jumper, good morning, ma'am.
Good morning.
The court does find probable cause for driving with a suspended license, third or subsequent offense. Count 2 is a traffic infraction, not for me. Hold on, let me mute this. Mr. Linder, first to you, sir.
Judge, it's recommending either an ROR to pretrial or keep the bond in place.
Okay, thank you, Ms. Chase.
Judge, in speaking to Ms. Jumper, she indicated that she wanted to hire a private attorney and did not wish for our office to be appointed. And it's my understanding she was just going to want to post her bond.
She's going to post bond?
Yeah.
Okay, thank you. All right, Ms. Jumper, I am going to leave your bond in place, but a condition of your bond is that you cannot bond without a valid driver's license. Do you understand? Ms. Jumper?
Yes, ma'am.
All right, and it's my understanding you're going to hire your own attorney, okay? Correct?
That's correct.
All right, let's see, Ms. Jumper.
Your Honor?
Yes.
I'm sorry, ma'am. Is there any way we could recall Miss Wells that was on the second look?
Sure.
Thank you.
Ms. Chase, did you have an opportunity to speak to Ms. Wells?
Oh, yes, Judge, I did speak to her.
Okay, at this time, do you have any mental health concerns, or are you secure in her ability to go forward with a plea?
Judge, I discussed the option of the plea, what that involved, and I feel that she's okay with going forward with the plea.
All right, thank you. So Ms. Wells, welcome back. You're still under oath and you're already sworn in. It's my understanding again, let's go through the plea colloquy that you wish to resolve your trespassing case, correct?
Yes. Yes.
And do you understand the charge against you?
Yes.
And do you understand everything that's happened here today?
Yes.
Is anyone forcing you to resolve this case?
No. Speak louder, Ms. Wells. No.
Are you under the influence of alcohol or drugs, Ms. Wells?
No.
And do you need more time to speak to your attorney?
No.
Do you have a right to go to trial, but you're giving that right up today by accepting this plea? Ms. Wells,
Yes.
do you understand that you're forever giving up your right to go to trial by accepting this plea?
You have to answer the judge if you want to go.
Yes.
Have you ever been treated for a mental or emotional illness, Ms. Wells?
No.
I'm not asking if you're a citizen. I just have to tell everybody that comes before me for a plea. Do you understand if you're not a United States citizen, that taking a plea today shall subject you to deportation proceedings?
Yes. Yes.
All right, do you wish to plea, ma'am? Guilty or no contest?
Huh?
Do you wish to plead guilty or no contest?
No.
All right, ma'am, I accept your no contest plea is freely, voluntarily, knowingly given, and there is a factual basis based on the police reports. I am going to sentence you to withhold of adjudication, court costs, and an order of no return to the law. How much time does she need to pay, Miss Chase?
I was going to request a civil lien.
All right, no problem. I'll convert your court cost, cost of prosecution, and PD application fee to a civil lien. What that means, Miss Wells, is that it's a civil judgment that's good against you for 20 years. If you ever do come into the money, you have to pay it off. Good luck to you, ma'am. If nothing else is holding you, you should be released today. All right, so let's go to our next person, Miss Watkins on page 3. What is all this? All right, is Miss Watkins at Maine? Left the bond in place with an order of no driving without a valid DL, and she's going to hire a private attorney on Miss Jumper. You're welcome. All right, so Miss Watkins, good morning, ma'am. The court does find probable cause counts 1, 2, 3, 4, and 5 are felony cases that you're being held no bond on. 1 through 4, no bond that I have no discretion over. Count 5 is a capias for possession of cannabis, and count 6 is a traffic infraction regarding an open container. Mr. Linder, is the state doing anything on count 5? Sorry, you're muted.
Yeah, Your Honor, the state would announce a no pros on case number 18-1732 and then 38.
All right, so the state has dropped the charge on count 5. So with regards to 1 through 4, Mr. Romero, does your office need to be provisionally appointed?
Yes, Judge.
All right, I will provisionally appoint the Office of the Public Defender to represent you on counts 1 through 4, ma'am. Once COVID is over, you will need to reapply to make sure that they keep representing you. Is there anything else on her case that we need to address?
No, Judge.
All right, good luck to you, ma'am. 18-1732.
Judge, did he say on count 5 there was a no cross on it?
Yeah, no, he just did it in open court. All right, so that takes care of Ms. Watkins. All right, next is Mr. Martinez. These are our DV mail dockets now. Mr. Martinez on page 4.
He's at Maine.
All right, thank you, Mr. Martinez. Good morning, sir. The court does find probable cause for touch or strike battery, domestic violence. Let me mute this so I can go to Mr. Linder first.
Showing at a Broward 2011 dealing in stolen property and grand theft, 18-month state prison. Recommending a $1,500 bond, no victim contact, noting that children were present in the home when this occurred.
Okay, thank you, Mr. Romero, sir.
Judge, I'm just going to be asking to be provisionally appointed.
Okay, thank you. I am going to set bond in the amount of $1,500, finding it aggravating that there were 4 children allegedly present when this occurred. Sir, you cannot have any contact with the listed victim, direct or indirect. Do you understand? That means that you cannot live with her, call her, text her, email, social media, have a family member or friend send a message to her for you. Do you understand? Or any other means of communications that I have not said. Understood. Also, based on the domestic violence nature, sir, cannot possess any firearms, weapons, or ammunition while your case is pending. Do you understand? And I will provisionally appoint the Office of the Public Defender to represent you during the pandemic. Once COVID is over, you will need to reapply to make sure that they keep representing you. Is there anything else on his case that we need to address?
Nothing else, Judge.
No, Judge.
All right, thank you. Good luck to you, sir. Next is Mr. Chin on page 4.
He's approaching, Judge.
All right, thank you. Mr. Chin, good morning, sir. The court does find probable cause for battery, cause bodily harm, dating violence. Mr. Linder, first to you. You're muted.
State is recommending $1,000 bond. No victim contact. I see no history. This is based on the allegation that he placed his hands around the victim's neck. My office had contact with the alleged victim. She does not want to have contact with Mr. Chin. Nothing further.
Okay, thank you, Mr. Romero.
Judge, at this time, no objection. I did advise, talk to Mr. Chen, the significance of no contact order. You will be abiding by that no contact order, direct or indirect.
Does your office need to be appointed?
No, he advised me plans on retaining private counsel, Judge.
All right, not a problem. All right, Mr. Chin, I am going to set your bond in the amount of $1,000. The conditions of your bond, sir, are that you cannot have any contact, direct or indirect, with the listed victim. Do you understand?
Yes.
That means not only can you not live with her, you cannot call her, text her, email, social media, send letters, have a family member or friend send a message to her, or any other means of communication that I have not said. Do you understand?
Yes.
You also cannot possess any firearms, weapons, or ammunition while your case is pending, of domestic violence nature. Do you understand?
Yes.
And again, I'm not going to appoint the public defender's office. Anything else on his case that we need to address?
No, Judge.
No, Judge.
All right, good luck to you, sir. Next is Mr. Correa on page 4.
He is approaching, Judge, at Maine.
All right, sir, good morning. The court does find probable cause for touch or strike battery, domestic violence. Hold on, let me mute this. Mr. Linder, first to you.
One moment, Judge. Judge, recommending ROR to pretrial, no victim contact. I see no history. My office had contact with the alleged victim. She does not want to have contact with Mr. Correa.
Okay, thank you. Mr. Romero?
Judge, and speaking, Mr. Correa, as a clean record, he's a registered voter. We're going to be asking for the court to consider a monetary bond as a pretrial release. I know he works. His schedule is quite flexible. So at this time, we're asking for a monetary bond on his case, Judge.
Okay, what amount are you requesting?
Judge, $1,000.
All right, thank you. Mr. Romero, state which should be heard.
How much was the?
1,000.
I'm fine with that, Judge.
All right, sir, you can, I am going to set your bond in the amount of $1,000. As a condition of your bond, you cannot have any contact, direct or indirect, with a listed victim. Do you understand?
Yes.
That means that not only can you not live with her, you cannot call her, text her, email, social media, or have a family member or friend send a message to her, or any other means of communication that I have not said. Do you understand?
Yes.
I will provisionally, actually, does your office need to be appointed?
No, he advised me he plans on retaining private counsel, Judge.
Okay, thank you. But you, sir, you also cannot possess any firearms, weapons, or ammunition while your case is pending based on the domestic violence nature. Do you understand?
He answered in the affirmative. Yes.
Okay, thank you. Is there anything else on his case that we need to address?
No, Judge.
All right, thank you. Good luck to you, sir.
Mother.
All right, next is Mr. Hamilton on page 4.
He's approaching, Judge.
Okay, thank you. Mr. Hamilton, good morning, sir. The court does find probable cause for battery, cause bodily harm, domestic violence. Mr. Linden, first to you, sir.
Recommending a $2,000 bond, no victim contact. He's already been arrested once this year for domestic violence battery against the same alleged victim. The case was dropped.
Okay, thank you. Mr. Romero, sir.
Judge, no objection.
Okay, thank you. I also find it aggravating that there was a child present, so I am going to set bond in the amount of $2,000. Sir, you cannot have any contact, direct or indirect, with a listed victim. Do you understand?
Yeah.
That means that not only can you not live with her, you cannot call her, text her, email, social media, have a family member or friend send a message to her, or any other means of communication that I have not said. Do you understand?
Yeah.
You cannot possess any firearms, weapons, or ammunition while your case is pending based on the domestic violence nature. Do you understand?
Yeah.
And Mr. Romero, does your office need to be appointed?
Judge, my understanding is his family's going to retain private counsel.
All right, thank you. Is there anything else on his case that we need to address?
No, Judge.
All right, good luck to you, sir.
Good luck, Judge.
All right, next is Mr. Wright on page 4.
Mr. Wright is here with me.
All right, Mr. Wright, good morning, sir. The court does find probable cause for battery, cause bodily harm, dating violence, and resisting an officer without violence. Mr. Linder, first to you. Let me mute myself.
One moment, Your Honor. Okay. Your Honor, the state is recommending a $5,000 bond, pretrial release of the GPS monitor and no victim contact. I would note, first off, this battery charge could certainly be upfiled potentially to a felony battery due to priors. Mr. Wright was convicted of a battery against the same alleged victim. He was additionally convicted of violating pretrial release conditions, that being a no contact order from another battery that occurred in 2020.
What year?
I'm sorry?
What years?
Well, the case that I was just mentioning was a 2021 case. The no contact order that he allegedly violated was from the 2020 case. Your Honor, the 2021 case, he was just placed on 9 months probation. June 23rd of this year. He's on probation till March 23rd of next year. And as I mentioned, he was arrested for a domestic violence battery against the same alleged victim last year. That was dropped. Additional priors include possession of firearm by convicted felon and resisting without violence, 2013. A battery arrest or a battery investigation in 2009 that no charges were filed. Burglary of a dwelling with battery, 01, VOP, 15.5 months state prison. Aggravated fleeing and eluding, misdemeanor assault, trespass, 99. Nothing further, Judge.
What's the case number for the probation case?
20-8471 CF10A.
All right, thank you. Mr. Romero, to you, sir.
Judge, Mr. Wright is a lifelong resident of Broward County. My understanding he is employed. He's a handyman. His wages fluctuate. On a good week, he can make anywhere up to $300. Now, he does live with the alleged victim. He has a family member that he can turn to in order to abide by the court's no contact orders, specifically of his father who resides in Pompano. The only person that monetarily can help in any way form is mother-in-law. However, my understanding is she's on a fixed income and gets Social Security. So there's no way his family is going to be able to afford a $5,000 bond. Judge, we were going to be asking on this misdemeanor offense for the court to consider a $1,500 bond on Mr. Wright's case and provisionally appoint our office.
All right, thank you. It looks like the listed victim is on, so let me see if she wishes to be heard from. Ms. Wilson, you would need to turn your camera on so I can have a conversation with you, please.
Hello?
You need to turn your camera on, ma'am.
Okay, I'm here.
All right, Ms. Wilson, good morning, ma'am.
You want to, may I speak, please?
Hold on, ma'am. You need to be sworn in first.
Okay.
You swear or affirm to testify to the truth, the whole truth, and nothing but the truth?
Yes, ma'am.
All right, put your hand down and please state your name for the record.
Joyce Wilson.
All right, Ms. Wilson, you are the listed victim and you're here without an attorney. You previously spoke with law enforcement, so I need to advise you that anything you say can be used against you at a later date. Do you understand?
Yes, ma'am.
All right, Ms. Wilson, what is it that you wanted to tell me?
I was upset, Your Honor. Mr. Wright did not hit me. I had took my medication. I got in the car and hit my head, and I accidentally told the officer that he hit me. But he did not hit me, officer. I hit my head. I had took my medication. And I was upset. We just had a disagreement. We're engaged to get married.
Does any party have any questions for Ms. Wilson?
Your Honor, frankly, based on that explanation, no, I don't.
All right, thank you. Mr. Romero, anything?
Judge, no, nothing further to ask the alleged victim, but I believe what we heard from the alleged victim testifying under oath, that just lends support to hopefully for the judge, for the court to consider my request, $1,500 bond, considering the fact that the strength of the state's case, I believe with, from what I'm hearing, I can only speculate that upon the case file learning of this information, I don't know if they're going to be that willing to go forward on this case. So therefore, I'm still asking on this misdemeanor offense for a $1,500 bond on his behalf, Judge.
All right, on case 28471 CF10A, I am going to hold him no bond for a 948.06 hold. He was just placed on felony probation with the same listed victim on 6/29/21. That's the order placing him on probation, actually 25 that's in the court file, and he's already allegedly violating the condition, his probation by allegedly battering the same listed victim. He's going to be held no bond on that case. Yes, ma'am. It's 28471 CF10A. He's going to have to go before Judge Holden, the new DV judge, in order to have the no bond modified. It looks like the allegations in that case involve domestic battery by strangulation, false imprisonment, and a violation of pretrial release. I have no assurances that he's going to stay away from the listed victim, so I am going to impose $5,000 on the new law. Once he posts bond, if his division judge does give him a release, he's going to be supervised at pretrial release level 2 with a GPS. You cannot have any contact, direct or indirect, with Ms. Wilson, the listed victim, even while you are in custody. Do you understand, Mr. Wright?
Yes, ma'am.
That means that you cannot call her, send letters, have a family member or friend send a message to her while you're in custody, or if your division judge releases you from custody, you cannot go where she's living, where she's working. You cannot call her, text her, email, social media, or any other means of communication that I have not said. Do you understand? You cannot possess any firearms, weapons, or ammunition while your case is pending based on the domestic violence nature. Do you understand?
Yes, ma'am.
And I will provisionally appoint the Office of the Public Defender to represent you during the pandemic. Once COVID is over, you'll need to reapply to make sure that they keep representing you. Anything else on his case that we need to address?
No.
Judge.
All right, thank you. Good luck to you. Good luck to you, Ms. Wilson. I hope you understand. All right, next is Mr. We did that case, Mr. Morton on page 6.
Mr. Morton's in here next to me, Judge.
All right, thank you, Mr. Morton. Good morning. The court does find probable cause. Count 1, a violation of an injunction for protection, domestic violence. Count 2, aggravated stalking after injunction for protection for domestic violence. Mr. Linder, first to you, please.
Your Honor, I'm recommending a $5,000 bond on count 1, a $15,000 bond on count 2. Pretrial release of the GPS monitor level 1 on both cases, no victim contact. In addition to these charges, Mr. Morton has a pending battery against a different alleged victim from this year, combined with charges of trespass and DWS with 2 priors. He also has a pending felony from 2018 for criminal use of personal identification information, grand theft, and felony credit card fraud.
I need those case numbers.
The battery is 21-2292 MM10A. The felony is 18-9562 CF10A.
All right, thank you. Based on the new law arrest and the court finding probable cause, I am going to revoke bond in those 2 cases based on the very serious allegations of in aggravated stalking with this alleged victim. You're going to be held no bond in case 21-2292 MM10A and 18-9562 CF10A. Mr. Romero, to you, sir.
Judge, I'm going to ask you to reconsider that and to not take any action.
I've already ruled, sir, so please, with the new law.
I have to make my record, Judge. I'm just asking you to not do that. Consider lesser sanctions such as level 1 house arrest. Now, I know he's been residing here for his whole entire life. He is working, doing home remodeling. Right now, he's been doing that for a couple of years. It's good. He's making approximately $600 a week on a great week. Judge, he does not live with the alleged victim. My understanding is that this time he just got accepted into a halfway house where he's trying to better himself. He wants to continue on that path. So based on that, Judge, I was going to be asking the court to set a $2,500 bond on count 1, $5,000 bond on count 2, with level 2 pretrial on Mr. Morton's behalf, and I'm going to be asked to be provisionally appointed at this time.
All right, thank you. Based on the allegations that he's allegedly been stalking her despite being served with an injunction on 4/20/21 of this year, on 4/22/21, it's alleged, I'm going to go through the allegations while I'm holding him no bond. On 4/22/21, he called the victim's workplace. Mr. Linder, you need to mute yourself. There's a big echo. On 4/22/21, it's alleged he called the victim's workplace multiple times and spoke to her at least once, which was recorded by the listed victim. And then when he was contacted by the police officer in Sunrise, he admitted that he called the victim. On 4/28/21, he called the victim's workplace again multiple times. It's at that time that the victim had to take the steps to allegedly block his cell phone number. On May 1st, 2021, he was allegedly seen outside the victim's workplace by the victim. He then yelled her name allegedly and went inside her workplace where she had to lock the door. He then allegedly made contact with her boyfriend in the parking lot and spoke to him, which was confirmed by the listed victim's boyfriend and provided a sworn statement. On May 8th, 2021, he allegedly sent his friend to the door of the victim's workplace. She opened the door to speak to the friend and observed the defendant allegedly walking towards the door. At that time, she again had to close the door and lock the door to protect herself. The incident was again confirmed by the listed victim's boyfriend, who witnessed the incident and provided another sworn tape statement. On May 26, 2021, it's alleged that he again called the victim's workplace multiple times, and the victim allegedly recorded this conversation. June 17, 2000. He allegedly called the victim's workplace and told her he knew her new home address and stated, "You better watch out, I know where you live." On June 21st, 2021, it's alleged he calls the victim's workplace. The victim recorded this conversation. And then it's alleged also with the other violation for protection of injunction. It was alleged that on July 4th, it's alleged that the victim was having a gathering with her boyfriend and two other witnesses while they were exiting her residence. It's alleged that she heard a male whistle at her. She looked over and saw the defendant who was there, even though despite this injunction, he was allegedly at her home. She allegedly told her that he needs to talk to her and he wanted to talk to her. She then allegedly told the defendant, "You're violating the restraining order." And then she had to call the other witnesses who then had to confront the defendant to get him to tell him to leave. It's at that point that he then walked away. A teletype inquiry confirmed the restraining order was active and served, and a not in custody was served at that time. So based on everything that I just put forth on the record, I'm setting my record. That's the basis for the court holding you no bond, and the two cases I've already said no bond on. I find that you're a danger to this listed victim and there's no other least restrictive means that can protect her from you, sir. With regards to the new laws, I am going to set bond on counts 1 and 2 at $5,000 each. Once you post bond, if your division judge does give you release on either your other two cases, are going to be supervised by pretrial release, level 1 with a GPS, strict house lockdown. You cannot have any contact with the listed victim, direct or indirect, even while you are in custody. Do you understand?
He answered in the affirmative, Judge.
That means that not only can you not call her while you're in custody, you cannot send letters, you cannot have a family member or friend send a message to her for you. Do you understand?
He answered in the affirmative.
Or any other means of communication that I have not said, sir. And if your division judge lets you out of custody, sir, your division judge is, because I've revoked bond on multiple cases, you cannot go by where she's working, either of her jobs. You cannot go by her home. You cannot call her, text her, email, carrier pigeon, any other means of communication that I have not said. Do you understand me?
Yes, sir.
You also cannot possess any firearms, weapons, or ammunition based on the domestic violence nature. Do you understand?
Yes, ma'am. A little louder. Yes, ma'am.
Mr. Romero, does your office need to be appointed, sir?
Yes, Judge. And just one final thing. I know the court was reading off thorough recitation of the facts. I don't know if the court was included in the probable cause affidavit. Mr. Morton actually surrendered himself or turned himself in at the Davie Police Station.
Okay, I understand he turned himself in, but based on this very multiple and harassing allegations, I find that there's no other least restrictive means to protect her based on what I've read.
I understand, but we felt it was important all the facts be shared.
Thank you, Mr. Romero. All right, I will provisionally appoint the Office of the Public Defender to represent you during the pandemic. Once COVID is over, you'll need to reapply to make sure they keep representing you. Sir, next is Mr. Green on page 6.
Mr. Green, come on up, please.
Mr. Green, good morning. The court does find probable cause for robbery by sudden snatching without a firearm or weapon. Count 2 should actually allegedly be felony battery, great bodily harm based on the allegation that the victim's nose is broken. Is there a legal objection from the state or defense?
Actually, Judge, I did have a note on that. In the probable cause, there's no medical treatment sought, no medical advice, medical records. It's her own words. She said she fixes it herself in the bathroom. So based on that, I would object to aggravating it.
All right, thank you, Mr. Linder. State wish to be heard.
I think for probable cause purposes, the officer can rely upon information provided by the alleged victim.
All right, thank you. I'll leave it as is. If the state gets medical records and confirms it, that they can file it as appropriate, but for now, I'll leave it as a touch or strike battery, okay? So Mr. Linder, what's the state's recommendation on counts 1 and 2?
Your Honor, I'm recommending a $2,500 bond on each count, noting that while it's PC for DV battery, the victim alleged that her nose was broken. Also, while I see Hallandale Beach address on the booking sheet in PC, according to the victim, they reside together in California. So it would appear he does not have ties to the community.
Okay, thank you. Mr. Romero?
Judge, my understanding is, in speaking to Mr. Green, that it's correct. He's been here for 5 days. He came down here to visit. He has family member here in our community. He came down from California. Judge, he is serving in the United States Air Force, been there since 2013. More importantly, this is his first contact with the criminal justice system. Now, I do understand count 1, I believe it's a robbery by sudden snatching. I believe it involves a phone. I did advise him he'll have his day in court to dispute these allegations. My understanding is the phone is actually owned by Mr. Green and under his name. Having said that, Judge, more importantly, hopefully the state can confirm, because he has no prior record, Judge, I was going to be asking the court to consider on count 1, a $2,000 bond, and on count 2, a $1,000 bond, and to provisionally appoint my office.
Does he need an order to reside in California?
Yes, Judge. Yes, Your Honor.
Okay. Thank you. So I will set bond in the amount of $2,000 on count 1, but based on the allegations that on count 2, I will set bond also in the amount of $2,000. So on both counts. Sir, the conditions of your bond, even while you're in custody, you cannot have any contact, direct or indirect, with the listed victim. Do you understand? That means that you cannot live with her, call her, text her, email, social media, or any other means of communication that I have not said. Do you understand? Sorry, I can't hear him.
So we currently live together in California, but she should be going back to her mother's.
Okay, not a problem. She just can't live with you. Do you understand?
Ma'am.
All right. You also cannot possess any firearms, weapons, or ammunition while your case is pending based on the domestic violence nature. Do you understand?
Ma'am.
And I will allow you to reside in California pursuant to the request of your attorney, because that's where you reside. And I will provisionally appoint the Office of the Public Defender to represent you during the pandemic. Once COVID is over, you will need to reapply to make sure they keep representing you. Anything else on his case that we need to address?
No, Judge.
All right, good luck to you, sir.
I'll call your family.
Next on page 7 is Mr. Caesar. This is a technical change of charge.
That's a technical change of charge, Judge?
It is, yes. Mr. Caesar, good morning, sir.
Good morning.
You originally came before me on magistrate, I believe on 6/1 or 6/2 of 21. It was very faint. I could barely read the date, but I believe it was 6/1/21. I originally found probable cause for aggravated battery with a deadly weapon, which is how the state filed charges. Well, and so at this point, unless there is a legal objection why I cannot do so, I am going to reinstate the $10,000 bond that I originally set, with all prior terms and conditions applying. No victim contact, direct or indirect, and no possession of weapons, firearms, or ammunition while your case is pending. Is there anything else on his case that we need to address?
No, Judge.
No, Judge.
All right, Mr. Caesar, good luck to you. Be in touch with your attorney so that they can let you know what's going to happen next. Your office is already appointed. Okay, so next on page 8 is Mr. Burgess. Is he at North Broward or Maine?
Burgess is here at Maine, Judge. Sorry.
All right, thank you. No problem. Mr. Burgess, good morning, sir. I do find probable cause for trespass. It's at a park, Mr. Linder. Does the state have an offer if he wishes to resolve?
Adjudication, time served, no return.
Thank you. Mr. Romero?
Judge, that's exactly what Mr. Burgess wanted to do today.
All right, thank you. Mr. Burgess, please raise your right hand for me, sir, to the best of your ability. Do you swear or affirm to testify to the truth, the whole truth, and nothing but the truth?
Yes, I do.
All right, you put your hand down and please state your name for the record.
Frederick Burgess.
All right, Mr. Burgess, it's my understanding you wish to resolve this trespass case, correct?
Yes,
Do you understand the charge against you?
yes,
And do you understand everything that's happened here today?
yes,
Is anyone forcing you to resolve this case?
no,
Are you under the influence of alcohol or drugs?
no,
Do you need more time to speak with your attorney?
no,
Do you understand that you are giving up the right forever to go to trial by accepting the state's offer today?
yes,
Have you ever been treated for mental or emotional illness?
no,
I'm not asking if you're a citizen, sir. I just have to advise you that if you're not a United States citizen, that by taking this plea, it shall subject you to deportation proceedings. Do you understand?
yes,
All right, and how do you wish to plead, sir? Guilty or no contest?
no contest.
All right, sir, accept your no contest plea is freely, voluntarily, knowingly given, and I find that there's a factual basis for this plea based on the probable cause affidavit. I will sentence you to an adjudication time served with an order of no return to Apollo Park. And how much time does he need to pay Mr. Romero?
1 year, Judge.
All right, now I'll give you 1 year to pay the court costs, sir. If there's nothing else holding you, you should be released today. Good luck to you, Mr. Burgess.
Good, sir. All right. Mr. Chappelle.
All right, next is Mr. Chappelle on page 8. All right, Mr. Chappelle, good morning, sir. The court does find probable cause for petty theft, second degree, first offense, and resisting without violence. Mr. Linder, does he have any priors or is he eligible for diversion?
Your Honor, I don't see any priors, but either way, I can't make an offer, so I'm just recommending an ROR, no return.
Okay, thank you. So it sounds like he may be eligible for diversion. So are you asking for an ROR with no return, Mr. Romero?
Yes, Judge, and I'm asking to be provisionally appointed at this time.
All right, no problem. All right, so Mr. Chappelle, I am going to release you on your own recognizance, but you cannot return to the Hollywood Donut Factory. Do you understand?
Understood.
All right, and I will provisionally appoint the Office of the Public Defender to represent you during the pandemic, sir. Once COVID is over, you will need to reapply if this case is still pending, okay? Be in touch with your attorney. Since you have no priors, there's a potential they could get you into the diversion program. Good luck to you, sir.
Contact our office and that number. I just gave you has a phone number. Good luck, sir.
All right, next is Mr. Marshall on page 8. Ms. Carr is here on his behalf. All right, Mr. Marshall, good morning, sir. The court does find probable cause for an open container. Ms. Carr?
Yes, Judge. Mr. Marshall has asked to resolve his case today to adjudication and time served in exchange for no contest plea and 6 months to pay court costs.
All right, not a problem. Mr. Marshall, please raise your right hand for me, sir, to the best of your ability. Do you swear or affirm to testify to the truth, the whole truth, and nothing but the truth?
Yes, ma'am.
All right, sir. Please state your name for the record. You can put your hand down.
Marshall.
All right, Mr. Marshall, it's my understanding you wish to resolve your open container case, correct?
Yes, ma'am.
You can put your hand down. I'm sorry about that. All right, do you understand the charge against you?
Yes, ma'am.
And do you understand everything that's happened here today?
Yes.
Is anyone forcing you to resolve this case?
No, ma'am.
Are you currently under the influence of alcohol or drugs, sir?
No, ma'am.
Do you need more time to speak to your attorney, Ms. Carr?
I just want to go home today.
All right, so just let me know if that changes, okay? If you need to speak to her, I'll put you on recall. Do you understand you have a right to go to trial and to fight this charge, but you're giving that up forever by accepting my offer of an adjudication time served?
Yes, ma'am.
All right, and have you ever been treated for a mental or emotional illness?
Yes, ma'am. Illness.
And is there anything about that illness today that prevents you from accepting this plea or understanding this plea?
No, ma'am.
And I'm not asking if you're a citizen, I just have to advise you that, do you understand if you're not a United States citizen, that taking a plea today shall subject you to deportation proceedings?
Yes, ma'am.
And how do you wish to plead, sir? Guilty or no contest?
No contest.
All right, sir, I accept your no contest plea is freely, knowingly, and voluntarily given. I'll sentence you to an adjudication time served, and I'll defer your court costs until January for 6. And good luck to you, Mr. Marshall. If nothing else is holding you, you should be released today, sir. Good luck.
Thank you.
No problem, sir. All right, next is Mr. Rogers on page 8. It's another municipal ordinance for open container. All right,
And Judge, I don't cover this municipality, just so you know. I think it's the city of Hollandale. I don't think they have a public defender.
Oh, okay, I will ask him what he wants to do then. Thank you, Ms. Carr. So, Mr. Rogers, good morning, sir.
Morning.
There is currently not an attorney here representing you. Do you wish to go forward without an attorney, or do you want me to reset this to see if we can get the city attorney for the city of Hollandale to come in and represent you tomorrow?
I just said I want to resolve it. I want to resolve it.
Okay, so raise your right hand for me, sir. Do you swear or affirm to testify to the truth, the whole truth, and nothing but the truth?
Yes,
All right, thank you. You can put your hand down and state your name for the record.
Richard Rogers.
All right, Mr. Rogers, it's my understanding that you wish to go forward without an attorney, correct?
Yeah,
You're making that decision of your own free will?
yes,
And you're asking this court to resolve this case. Are you willing to accept an adjudication time served, sir?
yes.
All right, and how much time would you need to pay that off?
1 year.
All right, I can give you 1 year. Do you understand the charge against you?
Yeah,
And do you understand everything that's happened here today?
Yep.
Is anyone forcing you to resolve this case?
no,
Are you currently under the influence of any alcohol or drugs?
no,
Do you understand you have a right to go to trial, but you're giving that up forever by accepting my offer?
Yep.
Have you ever been treated for a mental or emotional illness?
no,
I'm not asking if you are a US citizen. I just have to advise everybody that takes a plea before me. Do you understand if you're not a United States citizen, that taking a plea today shall subject you to deportation proceedings?
yes,
And how do you wish to plead, sir? Guilty or no contest?
no contest.
All right, sir, accept your no contest plea is freely, voluntarily, knowingly given, and I do find there's a factual basis for this plea based on the probable cause affidavit. I'll adjudicate you, sentence you to time served, and defer your court costs until 7/7/2022. If there's nothing else holding you, Mr. Rogers, good luck. You should be released today.
Thanks.
No problem. Next is Mr. Linares, who's Mora, who's a refusal, but I'm proceeding over the defense's objection. The court does find probable cause for exposing sex organs in public. Mr. Linder, first to you.
Your Honor, I don't see any history. That being said, based on the allegations in the report, I'm recommending a $500 bond, no return, no victim contact.
Okay, thank you. Mr. Romero.
Judge, I'm asking to be provisionally appointed. Mr. Linares having no prior record. I'm asking for an ROR in this misdemeanor offense.
Okay, thank you. Based on the very concerning allegations, I am going to set bond at $1,000 and with an order of no return, no contact with any of the listed victims. There are 3 alleged victims and the concerning statements that sexual comments that he made to them. I will provisionally appoint the Office of the Public Defender to represent him during the pandemic. Next is Mr. Skinner on page 9.
He's approaching, Judge, you're at Maine.
Okay, thank you. Good morning, sir. The court does find probable cause for resisting without violence and obstruction of highway or panhandling on count 2. Mr. Linder, first to you on count 1. Does he have any priors?
Your Honor, he does. First, just to put on a note on the record, if Mr. Skinner wishes to resolve this, the offer from the state would be an adjudication in 3 days in Broward County Jail. Your Honor, my concern is, first of all, that he's going to go right back because he told the officer that if he arrests him, he's going to go in front of the judge next day and he'll be right back out there where the officer came into contact with him. Additionally, he pled out a 2020 robbery by sudden snatching and battery and was sentenced to 20.5 months state prison as a habitual offender. 2019 battery on the law enforcement officer, resisting without violence, disorderly conduct, 18.5 months state prison. Resisting without violence, 2018. 2018 disorderly intoxication, resisting without violence. 2018 resisting without violence. 2018 resisting without violence. 06 loitering or prowling. Nothing further.
Okay, thank you. Mr. Romero, sir.
Judge, I spoke to Mr. Skinner and he had advised me at this time, he assures me he's not going to return to that location. Considering these are non-violent, Judge, I'm asking, or I'm inviting the court into plea negotiations at this time. I know he's homeless, he's not working, he can't afford to post a monetary bond, but regardless, he still wants to resolve this case today in exchange for his no contest plea. He is hoping that the court would consider extending an offer of adjudication time served.
All right, thank you. Mr. Skinner, please raise your right hand for me, sir, to the best of your ability. Do you swear or affirm to testify to the truth, the whole truth, and nothing but the truth?
Yes, ma'am.
All right, thank you. You can put your hand down and please state your name for the record.
Oh, Torvald Skinner, ma'am.
All right, no problem. Mr. Skinner, it's my understanding we wish to resolve both of these charges today, correct?
Yes, ma'am.
All right, and is anyone forcing you to resolve these cases?
No, ma'am, I'm not being compelled.
All right, and do you understand the charges against you?
Yes, ma'am, completely,
And do you understand everything that's happened here today?
completely.
Are you under the influence of alcohol or drugs?
No,
Do you need more time to speak with your attorney?
ma'am.
Do you understand you have a right to go to trial and fight these charges, but you're forever giving that up by accepting the court's offer?
That's correct.
Have you ever been treated for a mental or emotional illness?
No, ma'am, I don't think so.
Just in the abundance of caution, since you're not sure, is there anything about that potential mental illness that could be affecting your ability to accept this plea today?
No, ma'am, I don't have, no, ma'am.
All right, and I'm not asking if you're a citizen, I just have to advise you. Do you understand if you're not a United States citizen, that taking a plea today shall subject you to deportation proceedings, sir?
Yes, ma'am,
And how do you wish to plead, guilty or no contest?
no contest.
All right, sir, I accept your no contest plea is freely, voluntarily, knowingly given. I also find there's a factual basis based on the probable cause affidavits. I will sentence you to an adjudication time served on count 1. Count 2, I guess, the same thing, to run concurrent with each other. And how much time does he need to pay, Mr. Romero?
Judge, I'm going to be asking for a civil lien.
All right, and I'll convert your court cost to a civil lien, Mr. Skinner. What that means is that it's a civil judgment that's good against you for 20 years. If you ever do come into the money, you'd have to pay these off. Good luck to you, Mr. Skinner. If nothing else is holding you, you should be released today. All right, next is Mr. Garcia on page 9, who's waived his presence.
Judge, that is correct. I'm going to be waiving his presence. I spoke to him this morning. I do have mental health concerns. I'm going to be asking for a mental health screening. I'm going to be asking for his case to be transferred to Judge Lerner Wren.
All right, Mr. Linder, state wish to be heard.
No, Judge.
All right, so I will order a no return order to the publics and the police reports, leave the bonds in place, transfer the case to Judge Lerner Wren, and order a mental health screen.
And provisionally appoint my office, Judge.
Yes, my apologies. And I will provisionally appoint the public defender's office to represent him during the pandemic. Transfer to mental health court. All right, anything else on his case?
No, Judge.
All right, thank you. Next is Mr. Pablo on page 9, who is bonded for. Yes, that was Mr. Garcia on page 9 for the mental health screen. All right, no problem. Thank you. Next is Mr. Padlo, sorry, it's with a D, on page 9, who is bonded. For the record, I do find probable cause. Count 1, driving under the influence of alcohol or drugs, first offense. Count 2, leaving the scene of a crash involving damage to property. Count 3, DUI with property, damage to property of another. Anything else?
No, Judge. Your Honor, before we go into the next case, I don't know if we want to recall the interpreter. I did send the paperwork to Mr. Reynoso a little while ago.
Okay, thank you. Mr. Reynoso, are you ready to go on that case on page 11 that's on reset?
Your Honor, I'm just in the process of printing it and having a little bit of difficulty printing with my printer here. And it does seem very voluminous. It's about 9 pages. Would the court, we'd be respectfully requesting if the court would consider resetting it for tomorrow. It seems like a very long and detailed report, and I would like to have enough time to be able to prepare and make argument before Your Honor.
But no, sir, we can put it to the end of the docket. You have the same notice as the assigned public defenders who are in this courtroom, so you can either be at the end of the docket or when you're done reading.
Your Honor, just so Mr. Reynoso is aware, 3 of those pages are the warrant itself, not the actual affidavit.
I understand there's a timeline here, Your Honor. I would just, again, respectfully, Your Honor, if I can get till tomorrow morning to be able to take a look at this.
I've already denied your request, sir.
Okay, Your Honor. What time did you want me to log back on?
If you could just stay on the line, sir, and we'll call you at the end of the docket. I'm not sure when we're going to be done, but we're quickly approaching there.
Okay, Your Honor. I'm waiting to print this out then.
Okay, thank you. All right, on page 9, Mr. Randall is a medical reset. Next on page 10, Mr. Clark.
What's right down?
All right, thank you.
How you doing, Your Honor?
All right, I'm fine. Thanks for asking, Mr. Clark. The court does find probable cause. Count 1, criminal mischief, $200, but under $1,000, first offense. Count 2, disorderly conduct. Count 3, exposing sex organs in public. Mr. Linder, first to you, sir.
Your Honor, I'm recommending a $500 bond on count 3, no victim contact, no return. Mr. Clark also has a pending uttering a forged instrument from last year. Ms. Worrell has advised me that a warrant has already been taken to his assigned judge for a violation.
Okay, thank you. Ms. Chase?
Judge, I was going to, in reviewing this, he's been a resident here for about 2 years. He's currently unemployed, would be residing at Broward Outreach in Hollywood. Other than that, I'm not sure if there was anything other than another,
Miss.
I think the state mentioned another case that he was out on. Is that correct? But I didn't
Out
know
on
if there
a
were any
case?
other priors. I'd ask the court, I was gonna ask the court to consider pretrial for this misdemeanor.
I don't
He's already on pretrial, Ms. Chase, and they've already submitted a warrant to his division judge.
Understood, Judge. I just know at this point, he does not have the ability to post a monetary bond.
All right, thank you.
Your
Oh,
Honor.
and Judge, I do need to request a medical screen.
All right, I will sign that mental health screen.
Medical.
Medical, sorry.
And Your Honor, did they say that I had a
Medical.
case pending?
Yes, Mr. Clark. They have a case pending, sir, and uttering a forged instrument.
What is that? I don't know what that is.
Nothing on this case.
I don't have no,
I have nothing on this case. I just wanted to, before we go into the next case, so
I don't have no case.
Okay, all right, so let me finish this.
Yeah,
case,
that's.
sir. All right, so on count one, two, I'll leave as NC, but on count three, the exposing sex organs, I will increase the bond to $500 with an order of no return to the 7-Eleven and an order of no victim contact with the listed victim, direct or indirect. You may not know who they are, sir, but you cannot contact them by phone, text, email, social media, or have a family member or friend send a message to them. Do you understand?
No, I don't understand. Nothing that's going on. I'm thrown off at the point that they said that I have uttering of an instrument, a case pending, a criminal mischief. I don't even understand nothing that's going on right now, miss.
It's not,
Your Honor.
you're going to be on recall to the end of the docket, Mr. Clark, so you get your attitude right. We'll see you at the end. Next is Mr. Danny on page 10.
And Your Honor, on this, just let you know, after this case, guys, I can, I'm ready to proceed on Mr. Mercado's case, the motion release.
Which case?
Gerardo Mercado, you put on recall, you'd ask me just to let you know when I'm ready. to proceed. It's a motion to release.
Oh, okay, thank you. All right, so this is a 30-40 case, Mr. Mercado on the FMN docket. Mr. Mercado, good morning, sir.
Good morning, Your Honor.
All right, Mr. Linder, has the state filed charges?
Yes, Your Honor, state has filed information.
I can't hear you, sir. What is my charges, man? Could you say it again? Because I cannot understand.
Mr. Clark is on recall. Do not unmute that facility again. He is on recall. He needs to take a seat. He's at the end of the docket, or he'll be reset till tomorrow. All right, Mr. Mercado, and sorry about that interference, sir, and information has been filed. So at this time, your motion for ROR will be denied. Please be in touch with your assigned public defender so they can let you know what's going to happen next in the proceedings, okay? Is there anything else that we need to address on his case from either party?
No, Judge.
All right, good luck to you, sir.
Thank you very much. Have a great day.
All right, so back to the docket. Mr. Danny is next on page 10.
It's right here at Main, Judge.
All right, thank you, Mr. Danny. Good morning, sir. The court does find probable cause for trespassing, occupied structure or conveyance, and resisting without violence. Mr. Linder, first to you, sir.
Your Honor, Mr. Danny wishes to resolve the charges, the offer to withhold court cost, no return. It does appear that he lacks sufficient ties to the community. Paperwork indicates that he resides in the state of Pennsylvania.
Okay, thank you. Mr. Romero?
I spoke to Mr. Danny today. My understanding, yes, he was residing in Philadelphia. He's just relocated. He's been here for just over 2 months. At this time, he is looking for employment. He's been unsuccessful at this time, but he's still actively looking. He lives in North Lauderdale with his cousin who's helping him out at this time. Judge, considering these are nonviolent offenses, I'm asking misdemeanor offenses, Judge, I'm asking at this time for an ROR. Mr. Danny wants to have his day in court in order to dispute these allegations, and he would be coming back to court. I'd be giving him the phone number of the public defender's office to make sure that he knows when his presence would be required, Judge.
All right, thank you. The allegations is that he threatened to physically harm and beat the alleged bus driver's ass. That's the quotation. So I'm not going to release him ROR.
Judge, I understand the court's concern. Would the court consider them releasing him ROR to pretrial, where we still have to call him twice a week, Judge?
No, he has no ties to this community, Mr. Romero. He's from Pennsylvania.
Right, he's from Pennsylvania, but now he's relocated. He's been here over 2 months.
His permanent address on the booking report still shows a Philadelphia, Pennsylvania address.
My understanding, Judge, is now he's residing in North Lauderdale with his cousin.
Just looking for
Given priors, Mr. Linder?
Your Honor, I can run his priors, but while I'm doing that, 2 months still isn't strong ties.
I agree. The booking report's still not even updated to his cousin's address, Mr. Romero. It's still showing an address in Philadelphia, Pennsylvania, and this is the information that the officers received from him. So I'm going to leave the bond in place with an order of no return. And I'll provisionally appoint your office to represent him during the pandemic, Mr. Romero. Once COVID is over, he'll need to reapply to make sure that you all keep representing him. Anything else on Mr. Danny's case?
No, Judge.
All right, good luck to you, sir. Next on page 12 is Mr. Banas, Zach. All right, sir, good morning. The court does find probable cause for distributing or delivering methamphetamine. Counts 1 and 2. Count 3, distributing or delivering fentanyl. Count 4, distributing or delivering methamphetamines. Count 5, distributing or delivering fentanyl. Mr. Linder, first to you, sir. Let me mute myself.
Come on, Your Honor. Your Honor, I'm asking that the court keep the bonds in place. I'm also asking, should he post bond, that he be supervised by pretrial release of the GPS monitor level 2? Your Honor, based on the allegations in the arrest warrant affidavit, this is ongoing continuous allegations of drug dealing. I think a higher level of supervision for pretrial would not only be aware of where he is at all times, but also that he would have to provide a schedule beforehand would be appropriate considering the circumstances. I'm showing that Mr. Banaszak has a pending felony theft from last year, trespass 2016, theft 2015, theft 2014. Nothing further, Judge.
All right, thank you, Mr. Romero.
Judge, Mr. Banaszak has been residing in South Florida for 9.5 years. At this time, from what he advised me, he works off and on laying tile whenever he gets called upon. Then that's when work presents itself. Unfortunately, he is homeless at this time. So he has no address in order to go ahead and do level 2 pretrial. There's no one that can financially post his bond. He's not in a position to financially post his bond. Judge, he's asking you to take that into account in determining reasonable release conditions. I'm asking you to provisionally appoint my office on Mr. Banaszak's behalf.
All right, thank you. So I will leave the bonds in place with no as indicated by the judge that signed the warrants, and I will provisionally appoint the Office of the Public Defender to represent you during the pandemic, sir. Once COVID is over, you'll need to reapply to make sure that they keep representing you. It's a straight bond case. Good luck to you, sir. Next is Mr. Hernandez Martinez on page 11, who has waived his presence.
That is correct, Judge.
I do find probable cause. Count 1 is an out-of-state hold from Maryland for sexual abuse of a minor. Count 2 is an immigration hold. He's going to be held no bond on both of those counts and have extradition court on Tuesday. And then he has his immigration case to deal with. Anything else?
No, Judge.
Okay, thank you. Next is Mr. Williams on page 12.
Judge, he was a refusal, no legal objection. Oh,
He's here?
Preston Williams? No, Preston.
Oh, okay, okay.
And he refused, Judge, no legal objection.
All right, thank you. So we'll go forward on Mr. Preston Williams, just so there's no confusion there. The court does find probable cause. Count 1, possession of cocaine. Count 2, possession of fentanyl. Count 3, drug paraphernalia. 4, 5, 6, 7, 8 are K pieces and pretrial warrants that he's being held no bond on that I have no discretion over. I will leave the bond in place on 1 and 2 and ROR on 3, and I'll provisionally appoint your office to represent him during the pandemic. Anything else on his case?
No, Judge.
No, Judge.
All right, thank you. Next is Mr. Hernandez Polanco on page 13, who's a first-time refusal. So we'll give him one opportunity to do so because we'll give him one opportunity. If he refuses tomorrow, we'll go forward without him. Next is Mr. Butler on page 13.
Here, present, Judge, in Maine.
Okay, thank you. All right, Mr. Butler, good morning. The court does find probable cause for your out-of-county hold from Hamilton County. The allegations are you're being held no bond and you'll have to be trained. They're going to teletype Hamilton County that you're ready for pickup. Anything else on Mr. Butler's case?
No, Judge.
All right, sir, good luck to you. Next is Mr. Graham on page 13.
No urgent.
All right, thank you. All right, good morning, sir. Mr. Linder, was there a no victim contact on the 26801? Oh, I signed this. Here, okay, thanks. Why is it across county lines?
It's hard to tell, Your Honor, because this is another case where there was an issue summons. And Your Honor signed the probable cause paperwork, but there's nothing indicating whether a no contact order was issued. Actually, I don't, one moment, Your Honor. Gotta check, because what happened was this case was downfiled from a felony to a misdemeanor.
What was the felony case number?
28932 CF10A. There was a charge of child neglect. So, Your Honor, when he first was arrested in October of last year and he appeared before Judge Calton, she certainly ordered a no victim contact order, and there was a count of domestic violence battery. When it was downfiled to the misdemeanor, he
Would that contact not then apply to the misdemeanor down file?
I would argue that it would, Your Honor, because it's the same charge that was on the felony case, Your Honor. And there was no order from a court waiving or deleting the release conditions of no contact, Your Honor, which customarily happens when obviously when domestic violence cases get no process or no info. So, Your Honor, I think it is arguable that he did violate a no contact order. And at a minimum, obviously, whether that is the case or not, he had a release condition of no new law offenses. And it certainly would be aggravating in nature that the new law offense was committed at the residence of the victim of the pending case.
And I see that there was also an order of no return to the listed victim's home as well in the magistrate order on 2021.
Correct, Judge.
All right, so you find probable cause for burglary, unoccupied dwelling, unarmed. Is it across county lines?
Your Honor, I think that was done in error.
All right, so I'll cross that off. Mr. Linder, first to you, sir.
Your Honor, I'm recommending a $20,000 bond, pretrial release to the GPS monitor level 2, no victim contact, no return. In addition to the pending domestic violence battery, culpable negligence and criminal mischief. Your Honor, Mr. Graham has a previous conviction for attempted murder, second degree with a firearm or weapon. It was a 2012 case. He violated probation and was sentenced to 20 months in Florida State Prison. Nothing further.
Okay, thank you. Mr. Romero, sir.
Judge, Mr. Graham's been residing in our community his whole entire life. At this time, he's working. He works for a carpeting company, making approximately $14 an hour. Judge, he does have his mother that resides in our community, the only person that can help post his monetary bond. My understanding, though, is in speaking to Graham, she's not going to be able to afford anywhere close to what the state is asking for, Judge. We were going to be respectfully asking for a $5,000 bond on Mr. Graham's behalf, and along with standard pretrial, Judge.
All right, thank you. Based on the allegations that he intentionally violated a court's order, this is not the first time that he's alleged to have broken into the listed victim's home. It's alleged that he made entry to a broken window that he previously broke into when he previously gained unlawful access to her home. I am going to revoke his bond on 26801 MM10A because there was an order of no contact with the victim and no return to her home. He's going to be held no bond on that case, and on the new law, $20,000 if he's able to post bond pretrial release level 1. Strict house lockdown. Sir, you cannot return to the victim's home. Do you understand?
Sorry, say it one more time.
Yes, ma'am.
You also cannot have any contact with her even while you are in custody. Do you understand? I couldn't hear him.
The affirmative, Judge.
All right, that means direct or indirect, meaning you cannot go where she's living, where she's working. You cannot call her, text her, email, social media, send letters, have a family member or friend send a message to her, or any other means of communication that I have not said. Do you understand?
Little louder.
I understand.
You also cannot possess any firearms, weapons, or ammunition while your case is pending. Do you understand? Is that a yes?
Yes, ma'am.
All right, and I will provisionally appoint the Office of the Public Defender to represent you during the pandemic, sir. Once COVID is over, you will need to reapply to make sure that they keep representing you. Good luck to you, Mr. Graham. Yes, the revoked case is 26801 MM10A. No problem. Next is Mr. Bustanzi on page 14. Okay, he's bonded. Miss Sir, you've bonded, so your bond's been posted. I've just been advised, but I do find probable cause. Count 1, possession of methamphetamine, drug paraphernalia. 3 and 4 are traffic infractions. Count 5 is criminal mischief over $200, but less, and it's a subsequent offense. Anything else? Because his bond's been posted.
No, Judge.
All right, good luck to you, sir. All right, next on page, we did that one. That brings us to page 15, Mr. Leonard.
Here, present, Judge.
Did we do that? I see it. Okay, thank you. All right, Mr. Leonard, good morning, sir. The court does find probable cause for your out-of-county hold from Collier County. It's a failing to appear on a no valid DL. You have a $2,000 bond on that, but you're being held no bond on 2, 3, 4, 5, and 6, a violation of pretrial warrants that I have no discretion over. You're going to have to go before your division judge to address those. Mr. Romero, does your office need to be provisionally appointed on counts 2 through 6?
Judge, he advised me his mother's going to be retaining private counsel.
Okay, not a problem. So anything else on his case?
No, Judge.
All right, good luck to you, sir. All right, next, Mr. Lopez on page 15.
He's approaching, Judge.
All right, thank you. All right, sir, good morning. The court does make a finding of probable cause for home invasion, robbery with a firearm. I also make a finding of proof evident, presumption great, and at this time I am going to hold you no bond based on the allegations. 2 and 3, I do find probable cause for aggravated battery with a firearm, discharge of bodily harm, and aggravated battery with a firearm, actual possession. Mr. Linder, first to you, sir.
Your Honor, I'm recommending, based on the level of violence that the firearm was discharged and the alleged victim was shot, recommending a $75,000 bond on counts 2 and 3. Pretrial release of the GPS monitor level 1 on those 2 counts. No victim contact, no return, no firearms, weapons, or ammunition.
You're muted. Just I muted myself so you can speak.
Speak when you were speaking because of the echo. Judge, I'm just going to ask the court not to make a finding of proof evident, presumption great, which, as we know, is the highest standard that we have in criminal law. And holding no bond is, in fact, the most restrictive thing the court could impose. In my reading of this, it's the affidavit that we have at this time. The identification seems to have been made through anonymous jail informant and a potentially self-serving co-defendant who had agreed to testify against the individuals involved, other individuals involved. Also in her identification, she says on a scale of 1 to 10, she's possibly a 9 for certainty in terms of the identification, and that she had only met a couple times prior with this person, with Mr. Lopez prior to making that identification as well.
Okay, thank you. Mr. Linder, state wish to respond.
Your Honor, if you separate each identification, the information provided, then there's an argument to be made, but Your Honor, you have to taking all of them combined, Your Honor, and it doesn't appear that necessarily all these parties know one another. I think it provides adequate strength, Your Honor, to for the court to find proof evident or presumption great. And frankly, I do believe as the level of certainty of 9, 2, and 10, Your Honor, it certainly would be certainly a high level of confidence that the witness was certain as to who allegedly committed the offense.
So just and I apologize, you're done, correct? I didn't want to cut in. But I just made the comment too, as well as that this, potentially self-serving additional person who's arrested and been accused of this. And in terms of a lot of the total identification information that you have is regarding a Matthew Lopez, not Roberto Lopez. I believe there was a higher degree potentially of certainty with regard to that brother in terms of all the other information that was brought. This particular individual, Roberto Lopez, those were the only minimal identification issues with him. When you look at it, that was the only thing bringing him into the case, was the anonymous call from a jail informant and this one other witness. So that's just what I'm making my argument based on.
All right, thank you, Ms. Chase. Thank you, Mr. Linder. Mr. Romero.
Speaking to Lopez, he's 18 years old, been residing in our community his whole entire life. He hasn't graduated from high school yet. He intends on starting back up in fall at Miami Jackson High School. Now, he is over the summer been looking for employment. He's found some jobs doing plumbing. He lives locally in Miami with his mother. They rent, they do not own. They've been residing in the same apartment for the past 2 years. Judge, in reference to count 1, I'd ask for mitigation purposes for the court to take into account what my colleague argued and exercise your discretion and set a monetary bond on count 1. Judge, his financial resources are quite limited. I was going to be advising you a reasonable financial bond on counts 1, 2, and 3, and I would be asking for level 1 pretrial on Mr. Lopez's behalf, Judge, and to be appointed.
Okay, my apologies. I didn't mean to cut you off. All right, based on the allegations, as well as the very serious allegations that one of the victims was not only shot in the arm, but in his lower back, I am going to hold him no bond and set bond in the amount of $75,000 on 2 and 3. Once he posts bond, he's going to be supervised by pretrial release level 1 with a GPS monitor should his division judge grant him release on count 1. Sir, you cannot have any contact with the listed victims, direct or indirect, either of them, even while you are in custody. Do you understand?
Understand.
That means that you cannot call, text, email, social media, send letters, go where they're living, go where they're working, or go to school, or have a family member or friend send a message to them, or any other means of communication. I have not told you. Do you understand? Yes?
He said, yes, ma'am.
All right, thank you. You also cannot return to the incident location, the listed victim's home. Do you understand?
Spoken the affirmative.
Okay, and you cannot possess any firearms, weapons, or ammunition while your case is pending. Do you understand?
He said, yes, ma'am, again.
Okay, and you cannot have any contact with any of the listed co-defendants. Do you understand?
Yes, ma'am.
All right, Mr. Linder, you need to prepare a keep separate order, please.
Yes, Your Honor.
All right, and sir, I will provisionally appoint the Office of the Public Defender to represent you during the pandemic. Once COVID is over, you will need to reapply to make sure that they keep representing you. Good luck to you, Mr. Lopez. You need to be in touch with your attorney. These are very serious charges and you're facing life in prison if convicted as charged. Next is Mr. Hush on page 16. All right, sir, good morning. The court does find probable cause for grand theft over 5,000, but less than 10,000, fraud, uttering a false instrument, forgery on count 3, count 4, unlawful possession of personal ID or of another 4 or less, possession of blank fictitious unlawfully issued driver's license. Mr. Linder, first to you.
Your Honor, I'm recommending that the court keep the bonds in place on counts 1 through 3. I'm fine with an ROR on 4 and 5, no victim contact, no return. I am concerned based on the amount of the check that he allegedly tried to have cashed, Your Honor.
Okay, thank you, Ms. Chase.
Judge, and I can advise, I did speak to Mr. Hush. I know that he's resided in Broward County, or South Florida, his entire life. He's currently unemployed pending disability to at least start receiving disability. He lives in assisted housing in Dade County. He currently does not have any money in the bank, and no one that could potentially assist with bond. Given that information, I know that he has no ability to post a financial bond. I was going to ask the court to consider pretrial release.
Okay, does he have any priors?
Yes, Your Honor. He has been classified by the Florida Department of Law Enforcement as a career offender. Just cases that he went through DOC on. Out of Dade County in 2009, sale delivery of cocaine, 4 years in state prison. 2001, burglary structure, 4 years, 3 months state prison. 1996, attempted robbery with a firearm or deadly weapon, strong arm robbery. Another 2 counts of attempted robbery with a firearm or deadly weapon. And possession of cocaine, sentenced to a year in state prison. I'm also showing priors for possession of cocaine.
I haven't done anything since then. Since 2011.
Another possession of cocaine. Aggravated battery against a law enforcement officer, resisting with violence. Battery on a law enforcement officer, resisting with violence. Theft, burglary.
Your Honor, all of that is in my past. I have not done
Theft.
anything. I haven't been arrested. I have not done no prior.
Another theft.
I don't have anything.
Trespass.
Now, 2011 to now, Your Honor, I have.
All right, thank you. I am going to leave the bonds in place on 1, 2, and 3 with an order will return to South State Bank, as well as order of no contact, direct or indirect with the listed victim, Mr. Hush. Even though you may not know them, you cannot call, text, email, social media, or have a family member or friend send a message to them. I will also provisionally appoint the Office of the Public Defender to represent you during the pandemic, sir. Once COVID is over, you will need to reapply to make sure that they keep representing you. Anything else in Mr. Hush's case?
Yes, Judge, what did you say about 4 and 5?
4 and 5 I'll ROR, but 1, 2, and 3 I'll leave in place. Good luck to you, sir. Next is Mr. Castronova on page 16.
Is that main, Judge?
All right, thank you. All right, good morning, sir. I do find probable cause for burglary of a conveyance, count 1, touch or strike battery, count 2, count 3 is a probation violation for a homicide. So you're going to be held no bond on that. You'll have to go before your division judge. It's a 948 rule, but I'm not changing it. So with regards to 1 and 2, Mr. Linder, any other priors other than the homicide and the state's recommendation?
Your Honor, I can look them up. Frankly, I didn't check considering the nature of the charge he was on probation for. I was just going to be noting that he's on probation because he's happened to be the duty judge that signed the warrants. I can look it up, but I was just going to ask the court to keep the bonds in place with no contact and no return.
Okay, thank you. Mr. Romero?
Just request to be provisionally appointed, Judge.
All right, thank you. So I will leave the bonds in place as set by the division judge, Judge Yusan, and I will order that you have no contact, direct or indirect, with the listed victim. Do you understand?
Yes, Your Honor.
That means that you cannot go by where he lives, you cannot go by where he works, because I'm ordering no return to the incident location as well, the Cubby's Liquor Store. Do you understand?
Yes, Your Honor.
That means any other means of communications that I have not said. You cannot communicate the listed victim. Do you understand?
Yes.
You cannot possess any firearms, weapons, or ammunition while your case is pending. Do you understand?
I understand.
And I will provisionally appoint the Office of the Public Defender to represent you during the pandemic. Once COVID is over, you'll need to reapply to make sure they keep representing you. Good luck to you. You have the hearing tomorrow before Judge Yusan at 8:30 a.m. Next is Mr. Thomas on page 17.
Judge, Mr. Thomas wanted me to waive his appearance.
Okay, not a problem. Thank you. I do find probable cause for grand theft auto. His KP is for a misdemeanor battery and an out-of-county hold from Walton County that is being held no bond on. Does your office need to be provisionally appointed, Mr. Romero?
Yes, Judge.
All right, thank you. So I will leave the bonds in place on counts 1 and 2. I have no discretion on count 3. I'll enter an order of no victim contact on count 1, direct or indirect, and provisionally appoint the public defender's office. Anything else on Mr. Thomas's case from either party?
No, Judge.
All right, thank you. Next on page 17 is Mr. Montalvo.
He's approaching Judge Maine.
All right, thank you. Good morning, sir. The court does find probable cause for carrying a concealed firearm. Mr. Linder, first to you.
Recommending ROR, the pretrial no firearms, weapons, or ammunition, Judge.
Thank you. Mr. Romero.
Judge, he's just gonna post monetary bond.
All right, not a problem. So I will leave the bond in place at $1,000 with an order of no possession of firearms, weapons, or ammunition as a condition of your bond, sir. Do you understand?
Speak up.
Yes, yes, ma'am. I'm sorry.
No problem. And does your office need to be appointed?
No, Judge, he's gonna retain private counsel.
All right, not a problem. Good luck to you, sir. All right, next is Mr. Peterkin on page 17.
No problem.
All right, sir, good morning. The court does find probable cause for your 2 counts of violations of probation. These are signed warrants that you're being held no bond on. You do have a hearing tomorrow morning with your division judge at 8:30 a.m., Division FI. Ms. Chase, just please let his division attorney know that he has a hearing tomorrow, okay? And does your office need to be appointed? And I'll provisionally appoint the public defender's office to represent you during the pandemic, Mr. Peterkin. And once COVID is over, you will need to reapply. Good luck to you, sir. Next is Mr. Hall on page 17.
He is here at Maine.
All right, thank you. All right, Mr. Hall, David, the court does find probable cause for burglary with an assault or battery. I also make a finding of proof, evident, presumption great, but I do so without prejudice. Let me mute this because Mr. Linder, first to you.
Your Honor, I am going to be asking that the court hold Mr. Hall David no bond at this time with an order of no victim contact. I'm concerned that it would appear that this was a random act, another incident of road rage, Your Honor, that this wasn't just a matter of Mr. Hall David reaching into the vehicle, but that Mr. Hall David pulled and almost dragged the victim out of his own vehicle, Your Honor, and that the violence continued at that point thereafter. As far as history, Your Honor, it does appear that Mr. Hall David was previously in the military. I'm showing that in 2012, he was found guilty by summary court-martial for wrongful use of a controlled substance. There was a reduction in grade, 30 days confinement, and forfeiture of pay. Checking to see if there's anything else. That's all I see, Judge, nothing further.
Presumption great finding. You muted me. I'm sorry, I could hear the feedback. Judge, in reading this, I see just it's a probable cause affidavit. And it was the result, and it looks like there was a car accident or aggravating circumstances. And I just asked the court to take that in count and not make a finding of proof, evident, presumption great on the basis of the probable cause affidavit.
Okay, thank you. I maintain my finding, but I have not made a determination on bond yet. Let me hear from you, Mr. Romero.
Thank you, Judge. Speaking of Mr. Hall, Judge, he's been residing in South Florida for 20 plus years. He is now working. He works at the Hard Rock. He's been employed at the Hard Rock for the past 3 years as a bartender. More importantly, he lives here locally in Hollywood. He lives with his girlfriend and his 2 children. His girlfriend is a stay-at-home mom, and his whole family depends on Mr. Hall for their financial support. Judge, he's a registered voter in our community, has very strong ties, graduated from Hollywood Hills High School. More importantly, he served. He served in the Marines from 2010 to 2013. He's a war veteran, Judge. This is an isolated incident. He does not know the alleged victim involved, Judge, so there's not going to be any chance he's going to abide by the order as far as no contact. He was also, my understanding, he was also hurt as a result of the incident. He was also, I believe he was taken away in an ambulance, Judge. This was an isolated, momentary lapse in judgment. He will be coming to court. He will be facing the consequences. Judge, I'm asking at this time, based on Mr. Hall's strong ties, I'm asking the court at this time to exercise its discretion and impose a monetary bond. I'm going to be asking for the court to consider a level 2 pretrial. That would be with the monitor. We would know where he is at all times. That would still allow him to work in order to support his family. So we're going to be asking for level 2 with $7,500 bond on Mr. Hall's behalf. And that's what we're asking for. And we're asking to be provisionally appointed on this case as well.
All right, thank you. Although I did make a finding of proof evident presumption, great, I am going to exercise my discretion and set a bond in the amount of $20,000. Once you post bond, sir, you're going to be supervised by pretrial release level 2 with a GPS, which means that you can go to work and you can be at home, but you can only go to work with a pre-approved schedule. Do you understand? You also cannot have any contact, direct or indirect, with the listed victims, sir. You may not know him, but you cannot call, text, email, social media, send letters, or have a family member or friend send a message to him or any other means that I have not said. Do you understand? And I will also provisionally appoint the office of the to represent you during the pandemic, sir. Once COVID is over, you will need to reapply to make sure that they keep representing you. Is there anything else in Mr. Hall's case that we need to address?
No, thank you.
All right, sir, good luck to you. All right, next on page 18 is Mr. Lee. Okay, Mr. you have some information for me. Good morning, Mr. Lee.
Judge Georgia has dismissed the out-of-state hold on Mr. Lee.
Oh, okay.
He is now vulnerable for $100.
Okay, thank you. So Georgia has dismissed their out-of-state hold. So the court does not find probable cause for the out-of-state hold. It was originally no bond, but now it's been dropped or dismissed. So with regards to count 1, the possession of cannabis, I do find probable cause. Mr. Linder, is the state recommending an ROR on that? It was like 2 grams.
Right, I just need to, I'm looking at something else.
Okay.
Case number 21. Case number 213993 MM10A, which is the case number assigned to count 1, the possession of cannabis less than 20 grams. The state will be announcing a no info at this time.
Okay, so it's 213993 MM10A.
Yes, Judge.
Okay, so Mr. Lee, good luck to you. You have somebody lucky on your side. Both of these counts have been dismissed. Okay, so you're going to be released today.
All right, thank you.
213993 MM10A. State announced a no information. 213993 MM10A. All right, next is Mr. Belding on page 18.
He's here at Main, Judge.
All right, sir, good morning. So, find probable cause for criminal mischief over $1,000. Mr. Linder, hold on, let me mute before, actually, it's pretty low, so maybe that might not be feedback. Go ahead.
Judge, I'm asking that the court keep the bond in place with an order of no return. It would appear that Mr. Belding does not have ties to the community and resides in the state of Oregon.
Okay, thank you. Mr. Romero.
Judge, that is true. Mr. Belding is from Oregon. He advised me he's relocated from Oregon to here. He's been here since October 2020, so just shy of under a year. Now, at this time, he is not working. He is homeless. More importantly, from what he advised me, and I'm sure Mr. Linder will correct me if I'm wrong, he said he has a clean record. So we're asking for the court to consider releasing Mr. Belding today or order pretrial release.
Mr. Linder, does he have any priors?
I'll have to run his record, Your Honor.
All right, well, while you're doing that, based on the allegations that he was using racial slurs allegedly at the security guard before breaking allegedly multiple doors with a hammer, I am going to leave the bond in place with an order of no return. You cannot go back to Dania Beach City Hall, sir. And I will provisionally appoint the Office of the Public Defender to represent you during the pandemic. Once COVID is over, you will need to reapply to make sure they keep representing you. Take care. Next is Mr. Mitchell on page 19.
Mr. Mitchell is here, present at Main, Judge.
Good morning, Your Honor.
Okay, thank you. Good morning, Mr. Mitchell. The court does find probable cause. Count 1, possession of LSD. Count 2, possession with intent to sell or deliver THC. Count 3, possession with intent to sell or deliver cannabis. 4 is a traffic infraction. 5 is a probation violation for an armed burglary that I have no discretion over. You're being held no bond and will have to see your division judge tomorrow at 8:30. With regards to 1, 2, and 3, Mr. Linder, what's the state's recommendation? Is it to leave the bond in place?
Yes, Judge.
Okay, thank you. And Mr. Romero?
Just ask him to be provisionally appointed, Judge.
All right, thank you. So I will leave all of the bonds in place. Again, you'll have to see your division judge with regards to that no bond hold. Since it is an armed case, I can't change that bond for you, sir. You have a court hearing tomorrow at 8:30, and I will provisionally appoint the public defender's office to represent you during the pandemic. Good luck to you, sir. Judge Garcia Wood will see you tomorrow with regards to your violation of probation. Next is Mr. Johnson on page 19, who's a refusal. We'll give him an opportunity to volunteer. Sorry?
I spoke to him. He didn't want to appear for court. So at this time, on this unique situation, no legal objection.
Oh, okay, so sorry. Hand me back Johnson, please. Sorry. All right, so on Johnson, with a refusal, we will proceed.
He actually told me he didn't want to.
Sorry?
We're ready to go forward, Judge.
All right, thank you. So the court does find probable cause for a grand theft auto based on his refusal to come to court. I will leave the bond in place with an order of no return to the U-Haul and the police reports. And does your office need to be provisionally appointed?
Yes, Judge.
And I'll provisionally appoint the public defender's office to represent him during the pandemic. Okay, thank you. So that brings us to page 20. Mr. Hidalgo is a delete. Like I said, once he gets released from the hospital, it's because of the medical reset. It's been 3 days now. He'll be put back on. Next is Mr. Lang on page 20. Sorry. Mr. Lang on page 20, who's a second refusal. We're going to proceed without him. The court does find probable cause for a possession of fentanyl based on his second refusal to come to court. I will leave the bond in place and I'll provisionally appoint the public defender's office to represent him. Anything else on Mr. Lang?
No, Judge.
All right, thank you. Next is Mr. Hadler on page 20, who is also a second refusal, and there's no legal objection, so we will proceed in absentia. I do find probable cause count 1 petty theft, second degree, third or subsequent offense, and a violation of probation for petty theft. I'm ordering no return to the Lowe's, leaving the bonds in place. And does your office need to be provisionally appointed?
Yes, Judge.
And I'll provisionally appoint the public defender's office to represent him. That brings us to page 21. Is Mr. Dixon back from court?
Mr. Dixon's still not back, Judge, and not back yet.
Oh. He went to his division judge this morning, I'm told, even though he's on my docket. Right.
We can discuss what's going on here briefly.
Sure. If you let Mr. Romero know what's happening, it's a technical change.
Yes, Your Honor, he was first charged with premeditated murder. The court found proof evident presumption great and ordered him to be held no bond. The state filed a charge of second-degree murder, obviously a lesser included offense. But Your Honor, I think an argument can be made that it would just clearly, if proof evident and presumption great was found for a higher degree charge, that there would, for first appearance purposes, be proof evident presumption great for the lesser included. And I think there is a basis to adopt the previous finding, Your Honor. He will suffer no prejudice. He's going before his judge this morning to be advised of what he's been charged with.
All right, thank you, Mr. Romero. Do you wish to waive your client's presence based on that, seeing that he is before Judge Rothschild this morning, and he's the one that's going to have an Arthur hearing?
Judge, just to make sure, can we see if the Office of Public Defender is appointed on this case?
Yes, I appointed your office at the first appearance, and you all filed a notice of assignment public defender on 6/15. Maria Del Guardia filed in.
Based on him going in front of a assigned judge at this time, he's already going there. If I heard correctly, he's for an arraignment. At this time, no problem waiving his appearance, Judge.
All right, thank you. So in this rare instance, we will waive his presence. And I do make a finding of probable cause for murder in the second degree. And I also find proof evident presumption great, holding him no bond. The same conditions that I previously ordered at magistrates applied: no firearms, weapons, or ammo, and no return to the incident location. Anything else on this case?
No, Judge.
No, Judge.
All right, thank you. Next is Mr. Johnson on page 21. It's a change of charge. Let me see what the original charge was. He's
Actu-
also before his division judge this morning.
Yeah, we're gonna need him, Your Honor, because it started out as a PBL and is now a bondable offense. Obviously, I don't know if Judge Shear is setting a bond this morning.
Okay, so it's my understanding he's before Judge Shear, but now he's entitled to bond. What do you want me to do with his case, Mr. Romero?
If we could reset it for tomorrow, Judge.
Okay, we'll reset him for bond because he's before his division judge. I mean, she's not going to handle it this morning?
The problem is, Your Honor, I wish they would. I wish the ACs would notice that the person's being held no bond. It doesn't always get brought up to the assigned judge for arraignment. So they just go through the motions of the arraignment.
Okay, so we'll reset him tomorrow.
Yeah, I hope when we come in tomorrow, we find out from Ms. Cooper that a bond was set.
If it's been handled tomorrow, then we certainly tomorrow I'll find out when I speak to him. I'll let the court know, and we may tomorrow delete him from the docket. But as far as right now, I'm asking to be reset.
That's fine. We'll reset him for bond, PC and bond tomorrow. Okay, next is Mr. Williams on page 22. It's the perfection from yesterday. Ms. Chase, did you review? You did. Okay, and does the defense still maintain its objection? The drugs were tested. All right, thank you. So, Mr. Williams, at this time, I do find probable cause for possession with intent to sell or deliver cocaine, count 1, count 2, trafficking in fentanyl, count 3, committing a first-degree felony with a weapon, and count 4, possession of weapon or ammunition by a convicted felon. So, Mr. Linder, first to you, sir.
Judge, I'm asking that the court keep the bonds in place on counts 1 and 2. One moment, Your Honor.
Is that a PBL on count 3?
There's one thing I need to look at the PC for. Your Honor.
Question, it's related to the last post we did where there was a change of charges and he was entitled to bond.
It's Mr. Johnson. He's reset for tomorrow.
Right, no, I have a claim that was on the docket yesterday on the first docket, same issue, he was no bond on a first PBL, but they only filed shooting with gun and deadly missile, and that was not addressed yesterday, the bond, the fact that he was bondable. Is there a way we can put that on? It's the same situation.
It needs to go before his division judge because it wasn't brought up to me. So that's not something that we put back on my docket.
So just sometimes it gets skipped and then you start to stop.
Yeah, if you guys bring it up and let me know, then I address it. But otherwise, if it's not brought up, then it has to go before their division judge.
Yeah, Your Honor, looking at this in this situation and reading the specific allegations that Officer Curtis observed, Mr. Williams reaching into his pants and then towards the floor by his feet, which is the location where the firearm was found, Your Honor. I do believe there is grounds for armed trafficking. If the court agrees, I don't know if you want to put it on count 3 or just add that to count 2 and just, if that's the case, I would just recommend an ROR on count 3. However, if the court is inclined, however you want to do it though, I do believe that there is proof evident or presumption great for armed trafficking fentanyl. Should the court find proof evident or presumption great, I would be asking that he be held no bond on that count.
All right, so on count 3, I will make a finding of proof evident presumption great. Does he have any priors?
He does, Your Honor. I'm showing he has a pending possession of fentanyl and DWS habitual offender from last year. 2018, trafficking in substituted cathinones. He was sentenced to 18 months in state prison. 2017, possession of cocaine with intent to sell or distribute, 18 months state prison. Possession of cocaine, 2017. Unlawful use of false name ID, 07. Possession of cocaine, 06, 5-year state prison. Possession of cocaine, 04, and that was after a VOP. Possession of cocaine in 05 and 04. Possession of cannabis with intent to sell, 2000, 20-month state prison. Possession of cocaine with intent to sell or distribute, 99, VOP, 20-month state prison. 1998, possession of cocaine with intent. 2 separate cases, VOP, nothing further, Judge.
2 separate 98 cocaine with intent to sell.
Yes, Judge.
Okay, thank you, Mr. Romero.
Judge, I was explaining to Mr. Williams what happened procedurally. He is aware that yesterday the court did not find probable cause. I was talking to him if the court didn't bring in any additional information that he would be ROR'd. However, I was advising him at this time the state did provide information, and at this time the court found a probable cause. From what I'm also explaining to Mr. Williams, from what I heard correctly, I believe Mr. Lender is asking the court to find proof evident presumption great on a PBL offense. Having said that, Judge, if I am correct, Mr. Williams has been residing here in South Florida his whole entire life. He was working for a furniture company. Because of the pandemic, I understand at this time he is collecting unemployment, but he is currently looking for employment. Judge, at this time, he's right now living at hotels with his unemployment. But more importantly, Judge, he does have strong ties to community. He has his family that live here that can help him out during this process. More importantly, Judge, regarding the facts of this case, Mr. Williams, to my knowledge, was not the owner or registered owner of the vehicle. He was simply a passenger. He wasn't even the driver. He was a passenger in a vehicle that was occupied by 3 individuals. My understanding, Judge, I'm asking the court if the court found proof evident presumption great at this time to exercise discretion. My understanding, like I said, Judge, and speaking to Mr. Williams, none of the actual firearm or the drugs were actually found on his person. It was found under a seat. Under seat of a vehicle not belonging to him and not being occupied by other people. So at this time, Judge, I'm asking the court to exercise discretion. I'm asking the court to consider reducing the bond on count 2. From what he advised me, there's no way he's going to be able to come up with $75,000 bond. He's going to try and have his family help him, but we're asking for a total bond of $10,000 on Mr. Williams' behalf, Judge.
All right, thank you. Based on that prior trafficking, I'm not going to touch counts 1 or 2. Count 4, what was the state's recommendation? The firearm by felon.
5,000.
All right, and Mr. Romero, what's the defense's recommendation on count 4?
Judge, on count 4, would you ask for 2,500, Judge?
All right, thank you. See, the problem I'm having is that based on these allegations, it's alleged that he was observed by officers reaching into his pants and then placing the firearm on the floor underneath them. So based on that, I am going to maintain my finding of proof evident presumption great. He's going to be held no bond and will have to file a motion for an Arthur hearing with his division judge. I'll set bond in count 4 in the amount of $5,000. You cannot possess any firearms, weapons, or ammunition while your case is pending. Do you understand?
Yeah.
I will provisionally appoint the Office of the Public Defender to represent you during the pandemic. So that way they can help you out with that Arthur hearing and assist you with this case before your division judge. Good luck to you, sir. Once COVID is over, you'll need to reapply to make sure that they keep representing you.
I understand the court's ruling. Just for procedurally, to make sure I understand, the court found proof evident presumption great on the armed trafficking. I believe correctly what we should do is count 2 would be the PBL offense. Count 3, I believe, is an enhancement. I don't believe it's a charge by itself. I believe it would be an enhancement to count 2 in order to support the court finding on the PBL on count 2. Is that correct? Or
If your honor is inclined, as you already ruled, so it's not just being inclined, to hold him no bond for armed trafficking on 3, then I'd be fine with an ROR on 2, because typically someone wouldn't be charged with the trafficking and the armed trafficking of the same drugs.
So what I can do is I can just write armed on count 2, sorry. And then I'll write armed on count 2 so that it's less confusing. And I'll ROR on count 3. I'll make the same finding of proof evident presumption great on count 2. And he'll be held no bond on count 2. And then I'll ROR on count 3 so there's no confusion.
Thank you, Judge.
No, RR on count 3, the committing an armed first degree felony with a weapon. And on count 2, he's going to be held no bond because I've upgraded it to armed. Yep, 5,000 on 4. All right, good luck to you, sir. All right, let's go to our FMN docket. And then we'll come back to those 2 cases I put on recall. And second look.
Judge, I apologize. Who are we on?
Anybody on the second look or FMN dockets? And then I'll come back to the 2 cases that are on recall.
I have one Ray Johnson, Judge. I've been advised he bonded. He was on your second look docket.
Okay, so Mr. Johnson on the second look misdemeanor docket has bonded, so he's deleted.
And then I believe we have Mr. Michael Vellet.
Okay, so Mr. Vellet is next. He's on page 4 of the FMN docket.
Judge, my understanding is he came in, he was arrested on July 1st, so he came through the magistrate court over the weekend. No, actually, I believe, I'm not entirely sure when he came to magistrate court, Judge, but he's been.
I never came, this is my first. I was.
In detox.
Yeah.
And I'm assuming then he was able to refusal. Judge, he's looking for work. He's homeless. He has no one to post his monetary bond. He has a $1,000 bond on a possession MDMA. Judge, we're asking for the court to consider releasing him on pretrial release.
All right, Mr. Linder, on the defense's request on Michael Vellet on the second look, what's the state's position on a release to pretrial with random screens?
One moment, Your Honor. Fine with that, Judge.
All right, sir, so I'm going to release you to pretrial release, which means that you're going to get out today, but you have to call into pretrial release before 11 a.m. tomorrow. Please provide your phone number to pretrial before I continue with my orders.
Judge, he advised me he has no number. However, the number you can use to get in touch with him would be of his mother, and her number is 954-297-8509.
What's her name?
Cynthia Velez. Cynthia Velez?
Same last name.
Oh, I'm sorry.
Address is 5748 Northwest 27th Court, Lauderhill, Florida. 33313.
Did you get that, Ms. Worrell? All right, sir, you cannot use any drugs or alcohol while your case is pending because you are going to be randomly screened for drugs and alcohol. Do you understand?
Yes.
If there's an initial screen for drugs, that'll be your baseline. If on later testing, the levels don't go down, but instead stay the same, get higher, or there's a new drug or alcohol introduced, you could be violated and potentially held no bond. Do you understand?
Yes.
Okay, anything else on his case?
No, Judge.
All right, good luck to you. Call in tomorrow.
And this is the phone number to the offenders callers, okay? Good luck, go.
When will I be released?
Today. Judge, the next person would be David Montalvo on the second look docket.
Okay.
Good morning, Your Honor.
All right, good morning, Mr. Montalvo. Mr. Linder, what can you tell me?
You're on to $1,000 bond.
$1,000 bond on a possession of cocaine.
Okay, does he have any prior or pending cases?
Doesn't have anything pending. He does have priors. Burglary of a structure, 2018, a year in a day state prison. 2016, burglary of a dwelling. As far as Broward goes, I do not see any other felony offenses.
Okay, thank you. Mr. Romero?
Judge, my understanding that Mr. Montalvo has been in custody since the 2nd of July. He's been residing here for over 16 years. He just got a job as a mechanic in Hallandale. Judge, we're going to be asking on this non-violent offense for the court to consider releasing him on pretrial. I did advise him that the court would be inclined to subject him to certain rules, specifically random testing. I did advise him what that entails. He is prepared to go ahead and abide by that, so we're asking pretrial release at this time.
All right, so you're going to be released to pretrial release. That means you're going to get out today, but you have to call in tomorrow before 11 a.m. So please provide your phone number to pretrial before I continue with my orders.
Your phone number, sir.
Right now?
Yeah, nice and loud.
It's gonna have to be my brother's because my phone got this. 54230-2815. That is my little brother. My phone got disconnected yesterday.
What's his name?
His name is Jonathan.
Did you get the number? No. We need the number one more time, please.
One more time.
954-230-2815.
All right, sir, you cannot use any drugs and alcohol while your case is pending because you are going to be randomly screened for drugs and alcohol while your case is pending. Do you understand?
I do, ma'am.
All right, anything else on his case?
No, Judge.
All right, thank you. Good luck to you. Did I write this on the left? Because no drugs and random stuff. Okay, thank you. All right, who do we have next?
Mr. Dickey, comments on your second look docket, Judge?
Mr. Dickey, you said?
Yes, sir. Yes, sir.
Okay, no problem. All right, Mr. Dickey, it looks like it has a bond. Mr. Linder, does he have any priors or pending cases?
I just, as far as Broward, I see an old DWS who went through drug court for possession of oxycodone and alprazolam. Frankly, I suspect the reason he's here is because he refused to come before the court over the weekend holiday.
Okay, so what's the state's defense requesting pretrial?
Yes, Judge. I understand it wasn't a refusal. He was going through detox. He didn't feel well. He's feeling better today. We're asking for him to be released on pretrial release, Judge, with random testing.
Thank you. Mr. Linder, what's the state's position?
That's fine, Judge.
All right, sir, I'm going to release you to pretrial release, which means that you're going to get out today, but you have to call in tomorrow before 11 a.m. Please provide your phone number to pretrial before I continue with my orders.
Nice and loud.
Yeah, my friend, his number is 954-609-0932.
Did you get that, Ms. Worrell? Nope, you got to do it again and slower.
One more time. They can hear you. Nice and loud.
It's my friend Bart Corrigan. Bart, B-A-R-T.
And the phone number.
And the phone number is 954-609-0932.
Did you get that? All right, you cannot use any drugs or alcohol while your case is pending because you're going to be randomly screened for both alcohol and drugs. Do you understand?
Yes, ma'am.
All right, is there anything else on his case?
No, Judge.
All right, good luck to you, sir. You're going to get out today, call in tomorrow. All right, who else do we have?
Judge, I've been advised Richard Quigg bonded. Richard Quigg bonded, Judge.
Okay, he's bonded, so he'll be a delete. He's on the misdemeanor or MU docket, the MU DUI. So he's a delete. Okay, last is
Gary Hall. He is on your 3040 docket.
yes, he has 2 cases. All right, sir, good morning. Mr. Linder, these are 2 3040 cases. He's on page 2 and 3, has the state file charges.
One moment, Judge.
Sorry.
214504 CF10A is filed. Just need to check on the other one. Sheila, there's an issue with the what was uploaded. Would you be able to tell me on this case, the criminal mischief, what date Judge Shear made the finding?
It's fine.
6/5. So today would be the 32nd day, Your Honor.
So it's a little bit premature.
A little bit.
Do you want to set that second case for tomorrow then?
Which one? I'm sorry, which one?
The criminal mischief.
On the 215352, he's only been in custody 32 days. It's just 1 day shy of the motion for ROR.
the other case.
It's filed.
It's been filed.
That's from the bond bill.
Sorry, Ms. Chase?
May I call over to speak to Mr. Romero for a moment? I just have one question for.
Sure.
Judge?
Yes.
You want to get in touch with me?
I don't think I did. Okay, thank you. Yeah, I don't think I did it. Okay.
Mr. Romero, I was calling over there just to inquire because the one that is filed is the no bond hold. And the other account that has not yet filed is the $500 bond count. So I didn't know if you would not necessarily want to be released on that so he could still get credit, being the other case is no bond.
That's what I was just talking to him about. If I heard correctly, Judge, the case that the state file charges on, he was being held no bond. Since the state filed that case, the no bond hold is still staying intact. That means on the criminal mischief, the $500 bond, that's what I was talking to him. If the court were even inclined to grant the ROR even for tomorrow, it may not be in his interest. That's what I was talking about. Based on my conversation right now with him, he advised me at this time he wishes to withdraw the motion on case number 215352 CF10A, which is the criminal mischief, which currently has a $500 bond.
Okay, so how do you want me to word that, Ms. Cooper, on 215352, they want to withdraw their motion? Do you just want me to write that on the order for the finding?
Yeah, so they don't want to.
Okay, so I'll just write on 215352 CF10A. I can do it. He has two. Yep. Okay, and on the other one, sir, that as you have heard, the state has filed charges, so your motion for ROR will be denied on 214504 CF10A. You're going to be held no bond. You'll have to go before your division judge to address that no bond hold because it was a violation of pre-trial warrant that your judge sent. And on B 215352 CF10A, I will write that the defense withdrew motion.
And no action was taken, right?
And no action instead, because I originally wrote denied. I'll put my initials there. All right, anything else, Mr. Greer Hall?
Nothing else.
All right, thank you, sir. All right, so let's go back to North Broward for Mr. Clark. What page was he on?
Your Honor?
Yes.
Well, he was on page 10. He refused and asked to go back.
Okay, so we're going to proceed without him. All right, so already put the bonds before he was acting out. It's based on his very belligerent behavior this morning that we had to reset on him to the end of the docket. It looks like it didn't change his attitude. So I will leave the bond in place that I originally set at $500 with an order of no victim contact and no return. And I'll provisionally appoint the public defender's office to represent him. Anything else in Mr. Clark's case?
No, Judge.
No, Judge.
All right, thank you.
They still want a medical screen on him?
You still want a medical screen order on him, Ms. Chase?
Yes, I did. I did have an opportunity to speak to him, so I
Okay.
prepared that.
Okay, thank you. So I will add that as well. Okay, so now we're at the end of the docket. We need to recall Mr. Carvajal on page 11.
Judge, being that that's the last case, do you still need me to stick around or?
No, as long as you submit all the orders you need to, you're
I
excused.
emailed, did you get them? I emailed them.
Oh, my JA would be printing them out.
Oh, okay.
I see them. Okay, so I can print them while I'm here. You can go, Ms. Chase, unless you need a copy before you leave. Okay, you're excused. All right, so Mr. Reynoso, we need you, sir.
Hello?
Yes, sir. We're ready to proceed. We're done with our docket. You're the last case.
Okay. Yes, Your Honor.
All right.
Is,
Welcome back, Mr. Sunusi. All right.
Thank you. Thank you.
Mr. Reynoso, Mr. Linder, and Mr. Carvajal de Avila. I've already made my findings. Mr. Reynoso, did you wish to make argument or save them for the Arthur hearing with his division judge?
Sí,
Well, Your
señor
Honor.
Reynoso, yo ya hice mi dictamen y decreto. ¿Quería hacer algún argumento o quería guardarlos hasta el momento de tener su audiencia de Arthur ante su juez de división?
Your Honor, just to be clear procedurally, is Your Honor going to make a determination without prejudice on the issue of proof evident presumption great?
Yes.
Su señoría, procesalmente, para estar en la claridad, ¿usted va a hacer una determinación sin efecto de cosa juzgada con respecto a el elemento de prueba evidente de gran presunción? Sí,
Yes.
dijo la jueza Blackman, sí.
Yes, sir. So he is still entitled to have an Arthur hearing with his division judge.
Así que aún
Okay,
tiene
Your
el
Honor.
derecho a celebrar una audiencia Arthur ante su juez de división.
Then I'd like to go ahead, Your Honor, and briefly give some background on the information.
Entonces quisiera proseguir, su señoría, y brevemente dar algún tipo de información con los antecedentes.
It is important for this honorable court to know the context in which when these charges or allegations were brought forward.
Es importante que este honorable tribunal entienda o sepa cuándo fueron presentados estos cargos.
What's not included within the four corners of the arrest affidavit is that the mother and father of the alleged victim
Lo que no está incluido dentro del documento del atestado policial es que la madre y el padre de la alegada víctima,
were going through a contentious divorce proceedings.
que estaban atravesando un divorcio contencioso.
Upon information and belief, it is my understanding that the mother of the child had filed a motion for relocation.
Sobre la información que yo tengo, entiendo que la madre había presentado un recurso para reubicarse o mudarse con la criatura.
The mother was seeking to relocate to Texas.
La madre buscaba mudarse al estado de Texas.
Shortly thereafter, once that was presented in family court,
Poco tiempo después de que eso haya sido presentado en el Tribunal de Familia,
this investigation is launched.
se comenzó esta investigación.
Throughout the time in which this investigation has gone forward,
A través del tiempo que esta investigación ha proseguido,
Mr. Carvajal de Avila has adamantly denied the allegations.
el señor Carvajal de Avila ha negado fuertemente estas alegaciones.
Upon discovering that there was an investigation by law enforcement,
Al descubrir que sí había una investigación de parte de las fuerzas del orden público,
Mr. Carvajal de Avila retained attorney Walter Reynoso to represent him.
el señor Carvajal de Avila contrató al abogado Reynoso para representarlo.
On or about May 19th,
Alrededor del 19 de mayo,
Attorney Reynoso notified Deputy Luna that he was representing Mr. Carvajal de Avila.
alrededor del 19 de mayo, el abogado Reynoso informó al detective Luna que él estaba representando al señor Carvajal.
There are emails confirming these communications, Your Honor.
Su señoría, hay correos electrónicos confirmando estas comunicaciones.
There was also communications to the Deputy Luna that to please inform any and all other law enforcement officers that Mr. de Avila is represented by counsel.
También hubo informes y comunicaciones con el oficial Luna de que informara a cualquier y todo oficial de que el señor Carvajal de Avila estaba siendo representado.
And I bring all of this up, Your Honor, because most of what you see within page 3 and 4 within the arrest affidavit, I'm sorry, between 3 through 5 of this affidavit, Your Honor,
Y presento todo esto, señora, porque lo que usted ve entre las páginas 3 y 4, perdón, páginas 3 a 5,
there are a number of controlled phone calls that are made by law enforcement to my client.
Hay numerosas llamadas controladas que son hechas entre las fuerzas del orden público y mi cliente,
Post the notification to law enforcement that my client is represented by counsel.
ocurriendo después de la notificación de que mi cliente es representado por abogado.
I'm aware that this court isn't going to address any motions to suppress, but I thought it was important for Your Honor to understand and get a full grasp of what we are dealing with at this time concerning the potential evidence that the state's looking to introduce.
Estoy al tanto que no va a escuchar ningún tipo de recurso para supresión de pruebas, pero entiendo que es importante esta información para que entienda la magnitud de esto y entendiendo lo que la Fiscalía va a presentar como pruebas en este caso.
The allegations that are made are that my client penetrated the alleged victim, both vaginal and anal.
Las alegaciones son que mi cliente penetró a la alegada víctima vaginalmente y analmente.
Based on the arrest affidavit, a medical exam was conducted on or about 5/26 by Nancy Cotterman.
Basado en esa información y la declaración jurada, se hizo una examinación médica alrededor o aproximadamente el 26 de mayo por Nancy Cotterman.
The allegations are in direct conflict with the fact that there is nothing within the affidavit or any reference to medical reports wherein it's consistent that a male had penetrated a small child, leaving physical evidence that those types of...
Counsel, I'm sorry, I just...
Go ahead.
Thank you. Con esas alegaciones y el conflicto que hay de los hechos, no hay nada que esté en apoyo de la declaración jurada mostrando que hay exámenes médicos consistentes con que haya penetración de parte de un masculino.
Thereby, the conflict between the physical evidence and the allegations are important for this court to ponder and decide whether proof evident presumption great has been met in this case.
Por lo tanto, es importante que el conflicto se tenga en cuenta de la prueba física y las alegaciones para que tenga en cuenta el tribunal de la declaración de prueba evidente de gran presunción.
What was discovered was that the child did test positive for chlamydia.
Lo que sí fue descubierto que la criatura se examinó positiva por clamidia.
I'm not going to give a medical opinion, Your Honor, but the conclusions made by this report indicate that that's the only way to obtain chlamydia.
No soy un médico ni voy a hacer un dictamen médico, pero de acuerdo a este informe, la única manera de obtener esta enfermedad clamidia
is through sexual contact.
Es a través de contacto sexual.
However, that is in direct conflict with information that, based on my experience in handling these cases, is factually and scientifically true.
Ahora, sin embargo, eso, de acuerdo a mi experiencia, ese dictamen es factualmente y científicamente veraz.
More importantly, the obtainment of this chlamydia test was obtained and information obtained of my client having allegedly tested positive during the times in which he was represented, as I've indicated before.
Ahora, sin embargo, este examen y esta evaluación fue obtenida y esta información alegadamente obtenida de mi cliente que fue positivo durante el tiempo en el que él estaba siendo representado.
I would ask that the court not find proof evident presumption great, exercise the court's discretion in granting a bond. I'm sorry, go ahead.
Yo pediría que no dictamina que existe prueba evidente de gran presunción y ejercite su discreción para imponer una fianza.
My client was fully aware that there was an arrest warrant.
Mi cliente estaba totalmente al tanto y consciente de que había una orden de arresto.
Prior to the 4th of July holiday.
Antes del feriado del 4 de julio.
My client did not flee.
Mi cliente no huyó.
and in fact voluntarily surrendered yesterday.
Y de hecho se entregó voluntariamente ayer.
He has ties to the community,
Tiene vínculos a la comunidad,
brothers, and is fully gainfully employed.
hermanos, y también tiene empleo total y completo.
So we're respectfully requesting that Your Honor exercise discretion and permit Mr. Carvajal de Avila to be released on GPS with level 2 so he can continue to work.
Así que respetuosamente estamos pidiendo que su señoría ejercite su discreción, lo libere al señor Carvajal de Ávila con un monitor GPS nivel 2 para que él pueda continuar trabajando.
Nothing further from the defense at this time, Your Honor.
Nada más de parte de la defensa en esta instancia, su señoría.
Thank you, Mr. Linder.
Gracias, señor Linder.
Your Honor, I would ask that the court keep its finding of proof evident or presumption great in place.
Su señoría, yo pediría que el tribunal mantenga su dictamen de prueba evidente de gran presunción.
Is that interpreted? I couldn't hear Mr. Sinisi.
He did. I had to turn it down so that there's no
Okay.
Feedback.
Okay. Your Honor, there were two sworn statements provided in this matter, one by the alleged victim and then by her brother.
Su señoría, hubo dos declaraciones juradas presentadas en este caso, una por la alegada víctima y otra por su hermano.
Your Honor, Mr. Reynoso's implication is quite clear. It would appear that he's implicating that the father is making this up or coached his children to try to prevent his ex from leaving the state, which there's no evidence before the court of.
Su señoría, el señor Reynoso es muy claro que le está tratando de implicar de que el padre entrenó o preparó a sus chicos para que la esposa no pueda abandonar el estado, y no hay ningún tipo de evidencia de esa índole.
Guys, there's no evidence that either children were coached or told to say anything that was untrue.
No hay ningún tipo de prueba que muestre que hayan sido entrenados o obligados a decir algo que no sea veraz.
They were both qualified.
Ambos estaban calificados.
And I would note the victim's brother's testimony, while he did not witness any of the acts specifically.
Y tome nota que el testimonio del hermano, aunque no haya visto ninguno de los actos específicamente,
But he did witness is certainly of an incriminating nature, Your Honor.
I'm sorry, Mr. Leonard, you said what?
Additionally, Your Honor.
I'm sorry, Your Honor, I missed what Mr.
You
Linder
missed
said.
the last thing you said. What he did was incriminating.
It would be what he witnessed would be of an incriminating nature.
Pero sí, lo que él haya sido testigo ocular hubiese sido de naturaleza incriminante.
Additionally, Your Honor, while Mr. Reynoso is bringing argument before the court, grounds for a motion to suppress.
Adicionalmente, el señor Reynoso está presentando bases para un recurso de supresión de prueba.
Those arguments should be left to an evidentiary motion to suppress.
Y sus argumentos deben ser dejados para que sean presentados en una audiencia evidenciaria para supresión de prueba.
The evidence that both the defendant's girlfriend and her daughter tested positive for chlamydia, while the defendant also tested positive for chlamydia.
La evidencia de que ambos, la novia y la hija, como también el imputado, analizaron o examinaron positivo por clamidia,
Is additional evidence supporting that the proof of guilt is evident or that the presumption of guilt is great.
es también otra prueba de que la presunción es grande o que la prueba es evidente.
And I would note, Your Honor, that the information of how the victim would have contracted chlamydia did not come from the detective in this matter, but from the examiner at the Nancy J. Cotterman Center.
Y tomé nota de que la información de cómo contrajo clamidia no vino del detective, pero sino del centro Nancy J. Cotterman.
So I would ask, Your Honor, at this non-adversarial hearing that the appropriate amount of weight be placed on that information that was provided to the detective.
Y pediría que, ya que en situación adversarial, que es el peso apropiado de eso sea aplicado en este caso.
Nothing further, Judge.
Nada más, señoría.
Okay, thank you. At this time, based on everything, I have to meet you, Mr. Linder, sorry. At this time, based on everything presented by both parties, as well as everything in the signed warrant, I am going to maintain my finding of proof evident presumption great without prejudice.
Basado en lo presentado y escuchado y también lo que ha sido presentado escrito en la documentación y el atestado, sí va a mantener mi dictamen de prueba evidente de gran presunción.
Noting that the alleged victim's brother indicated to police under oath that he found it unusual that the defendant would be asleep in his sister's bed in a room that they shared.
Y también tomando nota que el hermano, en las alegaciones de que a la policía, que notaba que era extraño que el imputado se encontraría durmiendo en la cama de su hermana en una habitación que ellos compartían.
And when the brother woke up in the morning, the defendant was no longer sleeping in the sister's bed.
Y cuando el hermano se despertó por la mañana, el imputado ya no estaba durmiendo en la cama de la hermana.
As well as the information of the sexually transmitted disease that both the mother, defendant, and the child all had.
Como también el tema de que una enfermedad que se transmite sexualmente la tenían la madre, la hija y el imputado.
I understand that this report came about in May of this year, but the last alleged sexual contact was December of 2020.
Entiendo que este informe se produjo en mayo, pero que el último contacto sexual fue en diciembre del 2020.
So medically, that would explain why there would not be a physical penetration noted by the Nancy J. Cotterman Center.
Y eso explicaría por qué no habría una penetración sexual que haya sido visto por el centro de Nancy J. Cotterman.
However, there was still a sexually transmitted disease in the 8-year-old child.
Sin embargo, hay una enfermedad sexualmente transmitida en una criatura de 8 años de edad.
At this point, I am going to hold him no bond. He's going to have to file a motion for an Arthur hearing with his division judge.
En esta instancia lo voy a detener sin fianza y va a tener que presentar un recurso de Arthur ante su juez de división.
Because I am deeming him a danger to children in the community based on the familial relationship he had to the listed victim.
Porque estimo que es un peligro para la comunidad y las criaturas de la comunidad, dando en cuenta su relación filial con la criatura y la víctima.
Sir, you cannot have any contact, direct or indirect, with the listed victim, initials KR or her parents. Do you understand?
Señor, no puede tener contacto directo o indirecto con la víctima, cuyos iniciales son KR, ella o sus padres, ¿entiende?
He's muted, guys.
No tiene el micrófono encendido, caballeros.
Sí.
Yes.
That means that not only can you not call, you cannot send letters, you cannot have a family member or friend send a message for you, and that includes while you are in custody. Do you understand?
Eso significa que no puede llamar, no puede mandar cartas y no puede pedirle a un pariente o amigo que se comunique mientras usted está detenido, ¿entiende?
Sí.
Yes.
You also cannot have any contact, direct or indirect, with any minors under the age of 18, and that includes the listed victim's brother. Do you understand?
Y no pueden tener contacto con criaturas menores de 18 años, y eso incluye la víctima, el hermano de la víctima, ¿entiende?
Sí.
Yes.
Is there anything else on his case that we need to address?
¿Algo más en el caso que tenemos que abordar?
Your Honor, the only thing I would ask is which division judge is this assigned to?
Simplemente preguntaría a su señoría a qué juez de división está asignado este caso.
I don't know that yet because it is a signed warrant. It should be assigned us either probably tomorrow morning.
No sabemos eso porque es una orden de arresto firmada. Quizás mañana por la mañana se sepa.
Thank you, Your Honor.
Gracias,
All right.
señoría.
Thank you so much. Take care.
I
Muchas
appreciate
gracias,
your
cuídese.
patience, Your Honor.
Aprecio su paciencia, señoría.
No problem. Thank you for getting up to speed. I appreciate it.
Ningún problema. Gracias por ponerse al tanto. Lo aprecio.
Thank you. Stay safe.
You too.
Cuídese.
And Mr.
Igualmente.
Stitzy, thank you for your patience as well. Do you need the case number?
I think I have it. Is it 802-100-524?
Yes, you got it.
Yes. Thank you so much, Anna. Be safe.
All right. Thank you, everybody. Stay safe. Have a great rest of your day, and we'll see you all tomorrow. We did everything, yeah.